Okay, we are live and recording.
Thank you. Good morning and welcome to the Board of Trustees Executive Committee meeting, Executive Meeting and Board of Trustees of the State Bar. As a reminder, this meeting is being recorded. Board Secretary, please take the roll.
Cisneros,
Here.
Good, not present. Grande,
Here.
Sowell,
Present.
Tony.
Present.
Chair, you have a quorum.
Thank you. Next on the agenda is a call for public comment. Before we begin public comment, we'd like to remind everyone of some of the ground rules for speaking during this meeting. Specifically under the State Bar's policy regarding public comment, members of the public cannot exceed their time to another speaker. Any attempts to deceive the board by disguising your voice, using different aliases or names to participate in public comment or accent is, by extension, not allowed, as well as impermissible under the State Bar's policy against disruptive and/or disorderly conduct that may result in removal from the meeting. We appreciate your cooperation in maintaining a respectful and orderly environment for all attendees. We'd like to remind everyone that under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the board is the State Bar's governing body and is responsible for exercising oversight of the State Bar. The board, sitting as the executive committee, oversees the work of the attorney discipline system, as sitting as the regulation and discipline committee. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those who are attending by Zoom, you should have a function for virtually raising your hand. It is a hand icon and should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now and State Bar staff will call on you in the order that hands are raised. And for those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then the number 9. Again, doing so will alert staff that you would like to make a comment, and State Bar staff will call on you and open your microphone so that you can address the board. For those who are participating from a noticed location, please alert the State Bar staff member present in the room that you would like to make a comment. Due to time restrictions, we cannot allow more than 2 minutes for each speaker. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment. The on-screen timer will flash through the final 10 seconds. Okay, we ready to go?
I wanted to confirm that there are no members of the public at Trustee Grande's notice location.
No.
We do have one advanced sign up, but I'm not seeing this person in the attendee list, so I will move on to the one raised hand we have. Edmund Arufo, your mic has been enabled.
Yes, good morning. My name is Ed Rufo, and I'm a licensed California attorney, but I'm also the owner of a bar exam training program that sees approximately 1,000 students per year. I do have a broad perspective of future lawyers preparing for the bar exam, not just in California, but throughout the United States and around the world. And one of the common conversations I have with these candidates they're coming to join us as members of the State Bar. It revolves around the fees associated with the bar exam, as well as the overwhelming financial burden they have endured in order to join this noble profession we call lawyering. Under those circumstances, it's so disheartening to hear the current initiative to raise fees. This isn't just $150, it's $150 more added to the overwhelming costs involved with taking the exam. It's added to students that haven't been able to work because they've spent their lives over the last number of years preparing to pass the exam, carrying families, many of them being primary breadwinners, and a lot of them with overwhelming debt involved with their law school fees. It's not just $150. It's $150 more in the current economic environment. We all know that's money. Somewhere within CalBar or in the accounting firm that you've hired to look at this, there's somebody saying it's only $150. If it's only $150, do the right thing and look at your own budget. See where you can cut that only $150 instead of passing this burden on to the people that can't afford to take this exam. The people that are disproportionately harmed by this are the folks that can't afford this. They're the people that we need in the organization. The diversity and inclusion that we're looking to get in California depends on these people to join. These are the immigration attorneys, and well, I see I'm running out of time. I beseech you to please do your best to reduce these fees.
Thank you for your public comment. Next, we have Benjamin Cohn. Your mic has been enabled.
Hello. I wanted to update for the benefit of the members who are not on the Finance Committee or the Contracts Committee, especially that there on the agenda item 6.1, there is an opportunity where you discuss updates from the Office of Admissions to at least, if not take an action item, to still address the Humro report on the verifying that measure had not implemented the state board's approved accommodations on the February 2025 bar exam, despite the staff not singularly agendizing that as requested. You'll have the opportunity to discuss and ask questions of the staff about that and whether the board should take remedial action as it had seemingly wanted to do in May 2025 before that Humro report was commissioned, and the CBE's reasoning for not recommending that any remedy be provided should be overturned, because just providing the same remedies for other issues that measure caused on that exam, the fact that benefits the testing accommodation applicants who had those issues too, is not going to restore equal opportunity when only the testing accommodation applicants had the prejudice of not getting accommodations that were approved because they were deemed necessary to provide equal opportunity. That was only felt by them, so they need a different degree of adjustment, score adjustment, or other remedy than those that were approved for the other issues and those that were approved for everyone. The CBE's reasoning that it would be unfair to provide something that wasn't approved for everyone else just doesn't track with that specific harm. And that's especially true when the other issues that the remedies were for had already disparately impacted the testing accommodations applicants more, especially those regarding the scheduling of the exam and the locations of the exam and all that mess that happened before exam day. So please do discuss that at item 6.1. Thank you.
Thank you for your public comment. Chair, I do not see any more raised hands for public comment in the attendee list.
Thank you very much. With that, we'll then close public comment and move on to the agenda. First agenda item is the chair's report. Nothing to report today, so move on to the next item. Approval of the September 18th, 2025 Board Executive Committee open session minutes. Can I ask if there's any corrections or modifications to the minutes?
Like to move the minutes.
Thank you very much. I have a motion. Second?
A second.
Thank you very much. Motion is second. Roll call vote, please.
Good, not present. Grande?
Abstain.
Sowell?
Aye.
Tony?
Abstain.
Cisneros?
Aye.
Chair, I just would like to explain my abstention is because I was not at that meeting. I was not a member at the time, so that's why I abstain on the minutes for a meeting I did not attend.
Thank you.
With 2 ayes and 0 nays, the minutes are not adopted.
I think they are adopted.
The majority.
They are adopted.
There's no majority.
It's not a majority?
No,
I thought the majority of those present and voted.
there's only two. It's a tie vote, so it fails, right? 2 abstentions.
Abstentions don't count as a vote. I believe
We
this
can't count,
passes according to the rules that we did adopt.
I'm going to double check right now. We can
Yeah.
move on and come back to
Sorry.
it. But I also wanted to clarify that even though you were not at the meeting, the board policy manual does allow for those board members that are not present at the meeting to still vote if they reviewed the minutes. So I could understand why a board member could choose to abstain, but our policy does allow for that kind of a vote.
If you would review the rules, I will later, if necessary, bring it up for reconsideration, but I think it is passed.
Okay, next item, approval of proposed changes to conflict of interest code for designated employees. And we have a presentation. Shelby King and Brady Dewar. Hi.
You're correct. Okay, you're correct.
Wait.
Yeah.
The Political Reform Act requires the state bar to adopt conflict of interest codes for officers, employees, and consultants who make or participate in the making of business decisions that could impact their personal financial interests. There are 2 main parts to our conflict of interest code. First, the state bar's code adopts the model conflict of interest code that is promulgated by the California Fair Political Practices Commission in Regulation 18730. The model code defines reportable financial interests and disqualification practices, among other details. Second, the code tailors the types of reportable financial interests to the designated employee's official duties. Appendix A of the code outlines who are the designated employees who are subject to the code and who must file statements of economic interests or Form 700s. It also outlines the corresponding disclosure categories. Appendix B defines those disclosure categories. So for example, disclosure category 2, which applies to all designated employees, requires the reporting of financial interests from sources that are subject to the licensing, permitting, and regulatory authority of the state bar, so i.e. law firms and lawyers. Government Code Section 87306 requires the state bar to periodically update the code to ensure that the designated employees and disclosure categories are accurate. Additionally, the state bar needs to ensure that the model conflict of interest code from the Fair Political Practices Commission is updated in our code. After review, OGC, in consultation with HR, determined that some minor updates are needed to our conflict of interest code. Regulation 18730 in our code requires one minor change, just so that it conforms to the current version of that regulation. And that change does not apply to the state bar, so we will not need to change any of our practices. Additionally, Appendix A, which lists the designated employees, requires some minor updates. Those specific changes are outlined in the board item before you today, but the updates include the addition of some new positions, title changes, and organizational changes. Accordingly, we are requesting that the Board Executive Committee recommend that the Board of Trustees approve the updated code as attached to the item, and that the Board of Trustees then approve the amended code effective immediately.
Thank you. Now, trustees, any questions or comments? Not, may I have a motion?
I'd like to make the motion to adopt this.
I'll second.
All right, there's the motion being displayed. Roll call vote, please.
Good, not present. Grande,
Aye.
Soel,
Aye.
Tony,
Aye.
Cisneros.
Aye.
With 4 ayes and 0 nays, the motion carries.
Thank you very much. It's now time to move into closed session.
I could clarify.
Oh, yes, sorry.
Vice Chair Tony was correct. We do have a specific provision in our rules that abstentions are not counted towards the total number of votes, which means that the issue might pass even if there's no majority vote because their votes are not counted towards it. So thank you.
Thank you, everyone. Then with that, the item is recorded as having passed. And now with that, we will move into closed session. I don't know if we have an estimate on time in closed session. Not very much.
It should be very quick as they are minutes.
They're just minutes, so hopefully back into open session in 5 or 10 minutes. Thank you very much, folks. See you back in open.
Excuse me. Sorry, one moment, please. Very slow. Okay, we are live and recording.
Thank you. This is the Board Executive Committee of the California State Bar. We have just come out of closed session. There's nothing to report from our closed session. And with that being nothing else on the agenda, this meeting will be adjourned. Thank you very much, everyone.
Sure. So we're live and recording whenever you're ready.
Okay, very good. Good morning and welcome to the November 20th Finance Committee. Everybody hear me? Finance Committee meeting of the State Bar of California. As a reminder, this meeting is being recorded. Can I have our committee coordinator, Sam Tesoro, please call the roll for us?
Barahona,
Present.
Gore, not present. Grande,
Present.
Sowell,
Present?
and Trejo. Trejo also not present, but we do have a quorum.
Very good. Next on the agenda is the call for public comment. I would like to remind everyone that under the Bagley-Keene Open Meetings Act, public comments must pertain to items that are on the agenda or be related to matters that were within the jurisdiction of this agency and this committee. Specifically, the Finance Committee leads the oversight and review of the State Bar's budget preparation. The Finance Committee does not have authority over attorney discipline, and there are no attorney discipline matters on the agenda for today's meeting. State Bar staff will attempt to call members of the public in the order they appear on the agenda or in the attendee pool. And for those participating in person, please alert State Bar staff members present in the room that you would like to make public comment. For those who are participating via Zoom, you should use the raise hand function, and State Bar staff will attempt to recognize you in the order that your hands appear. And that for those who are participating via phone, you may use the *9 key. And again, State Bar staff will try to select you in the order that you appear. Due to time restrictions, we can't allow more than 2 minutes for each speaker. And please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer is 2-minute countdown will begin as soon as you start your comment, and you'll be verbally alerted once you have 30 seconds remaining. And the on-screen timer will start flashing during the final 20 seconds. And so with that preamble, Trustee Barahona or Trustee Grande, any public commenters at your sites?
Yeah.
Seeing none. Committee Coordinator Tesoro, do you have any folks that are you seeing any raised hands at this particular point in time?
We
Or-
currently don't have any hands raised via Zoom.
Okay. And there were no advanced signups, and there is no one here wishing to make public comment either. And so I think we can move forward with our agenda. So the next item on the agenda is our minutes from the last meeting. There are two sets of minutes here. I think we do have to, I'm looking at our General Counsel, I think we have to take these each separately. We can't do them both together, correct?
The minutes?
Yes.
No, that could be taken as one motion on both.
All right.
As long as the motion is clear that the motion is to approve the minutes, both sets of minutes.
All right. I'd like to try to do that if I can. We have the minutes from our September 18th, 2025 Finance Committee open session, as well as the minutes from our October 20th, 2025 Finance Committee open session. And so if I could get a motion to approve both sets of minutes, please.
Motion to approve both sets of minutes.
I second.
Very good. Trustee Barahona made the motion and Trustee Grande seconded. And Sam, can I get you to call the roll, please?
Barahona,
Aye.
Gore, not present. Grande,
Aye.
Trejo, not present. Sewell.
Aye.
3 ayes, 0 nays. Minutes are adopted or motion carries.
Very good. I think I skipped over the chair's report. I skipped over the chair's report because there is no chair's report, and so we'll keep it moving. Next item on the agenda is first business item, which is item 3.1, approval of the 2025 Quarter 3 financial statements report. And I think our Chief Financial Officer, Araceli Montoya Chica, will make that presentation. Good morning, Araceli.
Good morning, Arnie. Okay, there is a presentation for this first item. Is it showing on the screen? Oh, there we go.
I just want to make sure, can Trustee Barahona, Trustee Grande, can you see this?
Yes.
Perfect.
Okay, great. So this first item is the results of our Quarter 3 2025 financial statement results. I will first be going through the revenue results, and then I'll go into the expense highlights for the funds. Okay, I'm going to turn this way because it's hard to see. Give me a second. So first, starting off on the revenue bar wide, our total revenue is slightly above budget. It's actually well above budget by just over $10 million. And the composition of that overage is all of the funds that are listed here. So I'll be going through the funds that account for most of that surplus in revenue compared to budget, actual compared to budget. So first, starting off, the general fund is almost $5.5 million over budget. And this is a continuing trend into Q3 that we've seen. It's really a result of us receiving more mandatory fees, as well as a significant amount of late non-compliance fees. Of that, mandatory fees is exceeding our mandatory fees hasn't been a trend we have seen historically, but this year we are seeing that for the first time. We do anticipate having mandatory fees, or at least as of September, as of Q3 year to date, they are 1.5 million above budget, which is a good sign. But again, last year we did not meet our mandatory fee budget targets. So this is a positive occurrence, I guess, for the general fund to be exceeding our mandatory fees. Moving on to the Equal Access Fund, this one is actually below budget by about $500,000. So just as a reminder, all of the grants, so the Equal Access Grant, Equal Access Fund, the Grants Fund, the Legal Services Trust Fund, these are all pass-through grants. Pass-through funds. We get the funds, and then we disperse them to the grantees. We only get to keep a portion for the administrative cost reimbursement. So for the Equal Access Fund, it's just below budget because there's some undispersed grants that haven't yet happened. And there's also some pending funding we are waiting to receive to cover the cost of those administrative cost reimbursements. On the flip side, the grants fund is above budget by about 200,000. And this is because we did receive for that there are several grants under that particular one, and it's the Care Court and consumer debt. We did receive a little bit more in grant reimbursements than we had budgeted. So that created that small variance, being above budget. The Legal Services Trust Fund, it's almost $500,000 above budget as well on the revenue side. And this is a continuing trend we've seen. It's really mostly the IOLTA, the interest on lawyers' trust accounts. And that just keeps exceeding the budget. So it's really the driver, and we're going to continue to see that in Q4, even though we did do a budget amendment. Just the activity in Q3 also exceeded the actual daily balances, and the interest rates are higher than what was even budgeted and amended. So it's going to continue to exceed actuals and likely going the same trend into Q4. The admissions fund, as you can see here, is slightly above budget by almost $500,000. And this is because we're seeing a little bit of more moral character applications. The admissions funds, we also did do a budget amendment at mid-year in September to bring down the revenues to actual. So this is already amended, but at least through Q3, there was a little bit of additional moral character determination revenue there. And then finally, the Client Security Fund, similar to the general fund, we have received a little bit more mandatory fees. The Client Security Fund is funded by mandatory fees, so the Client Security Fund, just like the general fund, will see an increase in fees as well. Now I'm going to move on to the expense portion. So in total, our operating expenses, bar-wide, are below budget by about $4.5 million. And again, the composition of that variance is listed here. So starting first with the general fund is actually below budget on the expenses by approximately just under $4 million. And there are several reasons for the general fund. There's reduced spending in general services, so that's under building operations. We have spent less on utilities and engineering and repair, so that has created some savings there. We do have an ongoing trend of some IT and non-IT related projects that have been delayed or paused. So that also helped create savings under professional services and equipment. We have a little bit of savings in travel and training. We've incurred less expenses there than we had anticipated. And just as a quick offset to all of those savings, we do have collections that we haven't been able to achieve budget-wise from the Fresh Start Settlement Program. We are receiving, but not as much as we had budgeted. So all of those net savings in the general fund of just under $4 million. Equal Access Fund, as I mentioned, it's a pass-through fund. We are below budget purely just from delayed spending. So if we get the revenue, then we immediately essentially spend it. So we do have delayed spending and undispersed grants in the Equal Access Fund that's causing that short savings in that fund. Same for the grants. Actually, no, for the grants fund, we do have savings also of almost $500,000, and that's really just there's some personal vacancies that were funded or allocated, I should say, through the Care Court grant. Legal Services Trust Fund and the Client Security Fund are pretty much right at budget. They only have a small $100,000 variance. But the admissions fund, the last one, that one is under budget by about $200,000, and that's really just the timing of when those it's for exam consultant expenses. We're going to incur them in Q4 instead of Q3. So this is not an actual saving; it's just the timing of the expenditure being pushed into Q4. And that's all I have for the Q3 results. If anybody has any questions.
Questions from members of the committee about the report? Araceli, if I might just be able to ask you where we are right now, how would you sort of describe our overall revenue picture right now?
Did you say revenue picture?
Our overall sort of financial picture right now.
Okay. I want to focus, as always, on the general fund and the admissions. So bar-wide, we always look good, and that's really just because there is a lot of grant funding that comes in. But as I mentioned, grant funding is really mostly pass through. If we just focus on the general fund, our revenue is exceeding our budget more than I probably have seen in the last couple of years, again, with the additional increase in mandatory fees that we're seeing. And we have a significant amount of late fees that we've received, as well as investment income. Investment income has continued to exceed our budget. Revenue-wise, the general fund looks a lot better, and we might even be in a surplus position at the end of the year with the mandatory fees, the late fees, and the investment income, which is not something that we had seen again in the past couple of years. What that means is it helps increase the general fund reserve. As we recall, in 2028, we lose that $52 funding and we hit the fiscal cliff. So any reserves that we can build in the general fund between now and then will definitely be a positive.
Very good.
Yeah.
Very good. My only other question, and it just had to do with, this has come up a couple of times, and I just need a little bit more of a understanding of what this is. And that is, some of the other revenue we receive is from settlement funds, these Cypre settlement funds. And my understanding is that there has been a little bit of an uptick in that category. And I don't know if you just could explain to the committee what that is. And I know that that's something that is not going to be consistent and uniform year to year, but if you could maybe explain that just a little bit more.
Okay, sure. Yeah, we typically don't budget settlements because we don't know what's going to come in, and they really are just donations that, I don't have the background. I don't know if anybody in my team has the background of what type of settlements happen where the donations are coming in. We have seen them in this year in particular. We have seen them come in. It's for I have here in my notes just from class action settlement. I don't know exactly what it is, but the donations have come in a few $1,000,000, and they do get then redistributed to, I believe, legal service organizations. They go into the Justice Gap Fund, and I believe that gets then reallocated to legal service aid organizations.
Maybe what we could do is maybe just get
Yeah.
Erica.
I can provide some context. So this is required under the Code of Civil Procedures for these Cypre funds. This comes out of class action lawsuits. And what happens is once the class award has been distributed, there's two things that can happen. A judge can award this through a Cypre award that comes to often the state bar to be distributed amongst legal aid organizations. It also can go to essentially like the unclaimed property as well. So those are two things that happen in this instance. A judge awarded those funds that were resulting from a class action to the state bar to be administered for a Cypre award. That doesn't always happen. And just for context, there are some active conversations happening to make this possible to further promote how this occurs under CCP Section 384, but that's where this award came from. So that's kind of how these awards do come to the state bar from time to time. As Araceli pointed out, it's not a consistent revenue source.
Got it. Erica, could you just maybe probe a little bit more? So it sounds like as you mentioned, there's some discussions to try to figure out how to make this happen more in a more regularized fashion. Is that something that we have some input into, or how does that work?
Yeah, so this is something that the Office of Access and Inclusion is involved in and exploring with other legal aid organizations. There already is like I said, a statute that provides for this. What they are looking into is increasing awareness of this by the courts so that they can make this designation. And that's being pursued, to my knowledge at this time, through possible exploring, I think they're in the exploration stage, of possible amendments to the California Rules of Court to create more awareness of that particular Code of Civil Procedure section.
Okay, so just so it doesn't require a statutory change.
It does not require a statutory change, and this is something that would not be within the Title IX Rules of Court, which are those rules that relate to the state bar. This would be in different rules of the California Rules of Court, and so that's likely something that would go through the Judicial Council as opposed to be worked up by the state bar.
Okay. I actually think this would be something maybe worth having a conversation with the legislative liaison group, as well as maybe just talking to the chair and vice chair a little bit about as well, just to make them aware of what's happening with this, and maybe to have some direct conversations with the courts about it. Okay. But with that, any other sort of comments or questions? Can I get a motion to move this item?
I move.
I'll second.
Okay, moved by Trustee Grande and seconded by Trustee Barahona. Sam, could I get you call the roll, please?
Barahona,
Aye.
Gore, not present. Grande,
Aye.
Sowell.
Aye.
3 ayes, 0 nays. Motion carries.
Araceli, just so I'm clear, that particular item is going to come before the full board as well?
Correct.
Okay. And that'll happen during the course of this board meeting?
Correct.
Okay.
Yes.
Let's move on to item 3.2.
Yes.
Approval of the 2025 Quarter 3 Investment Report.
Yes. So this next item, I don't have a PowerPoint presentation. All of the details really are briefly or are detailed in the attachment to the agenda. Our quarter 3, just total market value of the investments is around $380 million. The interest rates have actually maintained above 4% so far. The average quarterly rate of return for all of our investments is about 4.21%. And the detail of, or the breakout of the investments that we hold, they are all excuse me, with Wells Fargo, and we do follow the California investment policy, so they're very secure investments, primarily in short-term commercial paper, some government home loan notes, and then, of course, our money market. Attachment A2 lists the detail of all of those investments. It is $380 million, but most of that is really the legal services trust fund investments that is restricted. But the market continues to do okay. There was a couple of rate cuts, so the newest investments that I have been able to purchase, the rate has decreased. As you can see, the older investments were closer to the mid-4, upper, closer to 5% yields, but now they are coming down to low, very, very low 4%, and probably will start dipping into the high 3s in the near future, especially if the Fed cuts more rates. But for now, the details are listed in attachments A1 and A2, but there's sort of business as usual for the investment results for the quarter. If there's any questions.
Questions from committee members on the investment report? Just one quick one from me, Araceli. Is there, I can't remember this and I should know this, is there a certain percentage of funding that we put in the LAIF versus how much we do with in the Wells Fargo accounts?
It's discretionary. Usually I try to see who has the highest rate. LAIF tends to be a little bit trailing. So we always, myself along with the controller, we always look at the rates. And so far the money market seems to be outpacing LAIF. So we try to move more funds there to earn more investment income.
Got it.
But there's no prescribed percentage, if you will, to put into LAIF.
And I know at one point in time, Trustee Trejo had some interest in how we were distributing this. Have the two of you had a chance to chat about that, or?
No, we have not connected.
Okay. All right. I'm just wondering if he still has maybe some thoughts in this regard. But if there are not any other comments or questions from committee members, I'd like to move this item as well for adoption.
I'll move it.
Moved by Trustee Barahona
I'll second.
and seconded by Trustee Grande. Sam, can I get you to call the roll, please?
Barahona,
Aye.
Gore, not present. Grande,
Aye.
Trejo, not present. Sowell.
Aye.
3 ayes, 0 nays. Motion carries.
And if I'm correct on this item does not have to go to the full board.
It's going on consent.
Say it again?
It's going on consent.
It's going on consent. Okay, very good. All right, item 3.3. Request and approval for 2026 spending authority pending formal budget adoption and 2026 preliminary budget assumptions.
Yes, this next item as well, I don't have a presentation. It's a rather short one. It is an agenda item that we bring forth every November, and it's really just to seek approval for spending authority. Our budget does not get adopted until end of February. So every year we ask the Finance Committee to approve our spending authority for the first, essentially almost the first 2 months of 2026, from January 1st through whenever the budget gets adopted. Again, it's typically end of February. Right now, based on our estimates and historical analysis we are asking authority to spend about $120 million for the first couple of months. But just to be clear, about $90 million of that is grant funding that we're planning to disperse sometime between January and February. So most of the funding is going to be funding that we've received through grants and then dispersing it to grantees. Included in here as well is just some brief highlights of some of our key underlying assumptions as we're building the budget. It is budget season right now, and the team is hard working on getting the 2026 budget prepared. So listed in here is just a couple of bullet points that I wanted to highlight of what are some of the assumptions that we are including in the budget as we are working to develop it. I'll just highlight a few. So we are continuing to see a minimal growth rate in the licensee population. Our Office of Research and Statistics works very closely in analyzing those numbers, and they provide us that. So for 2026, we are anticipating to have only a growth rate of 0.4%, so it's pretty small. Last year, I think it was 0.2, not even 0.2%, so it's a little bit higher, but it's still very minimal overall. We always apply a CPI index to expenditures that, outside of personal expenses and other known, we always apply a CPI index, and we use the same consistent index year over year. So it's 3.3% based on the latest California CPI that we have. 2026 will be the first year of the two contractually COLA that we negotiated at 2%. We did complete our reduction in force in 2025, so 2026 will be the first year we see a lot of those positions became unfunded, meaning they're going to go away. And we always add a vacancy rate into our budget. So based on our preliminary assessment of the vacancy rate, excluding all of the reduction in force positions that are not going to be funded, we're at about 9.5% of vacancy rate that we're planning on including in the budget. And then as well reflecting on possibly some of the admissions fee increases that we're going to discuss later at the full board meeting. That's particularly in the admissions fund. And those are just some of the key assumptions that I highlighted in this agenda. If there's any questions.
Questions from board members?
I just have one question. Thank you so much, Araceli. In terms of the assumptions going forward, is given the reduction in force and the vacancies that we'll see, I guess my question is, are we planning for some expense for temporary support? I suspect that this is going to impact the teams pretty significantly, and planning for some expense for some short-term projects or short-term support feels kind of important, but just curious about that.
Yes, so a component of our budget is allocated to temporary help. Every office, certain offices in particular, the ones who get, so for example, billing season is very busy for the Office of Finance as well as Office of Regulation, and we usually do have some temp help, admissions as well. So there is a portion in the budget that's specifically allocated for temp help that we do have.
Got it. Thank you so much.
Yes.
Other questions? I mean, Araceli, I know this is a relatively just pro forma item, just to deal with the lag in terms of the adoption of the budget. And the assumptions going into building next year's budget appear reasonable to me. And so with that, I would just ask if I could get a motion to move this item as well. Can I go Trustee Grande this time and then Trustee Barahona?
Yeah, I move the motion.
I'll second.
Very good. And with that, Sam, can I get you to call the roll, please?
Yes, Barahona,
Aye.
Gore, not present, Grande,
Aye.
Trejo, not present, Sowell.
Aye.
3 ayes, 0 nays. The motion carries.
And can you also tell me the disposition of this item? Does this need to go to the, does not?
No, this is finance only.
Okay, finance only. All right, we have one last item before us, and that is item 3.4. And Araceli, if I can get you to present that item as well. This may be one of the fastest finance committees we've ever had.
Yes, this item is also an item that's brought forth annually, typically November, and it is requests for approval and adoption of the schedule of charges and deadlines. The schedule of charges and deadlines lists all of the fees that we charge, the related rule, and the amount that we are going to increase the charges and any relevant deadlines as well to any of those fees that we charge. Just to highlight some things in this agenda item, the 2026 licensing fees remain the same. So the breakout of that is really in tables 1 and 2. 2026 active fees remain at $598. There's an option to opt out there, but just in total, it's $598. And then for inactive fees, it's the same as last year as well at $205. There's a couple of included in here every year based on the board adopted policy is to apply a CPI every year that we don't do a fee assessment. So every 3 years we are going to do a fee assessments for both the admissions fund and the general fund to ensure that the fees we charge have kept up with the expenses. Outside of those years, we do apply a CPI index, which we've continued to do. Other items I wanted to highlight, there's at the regular board meeting, there's going to be three items that are going to be taken up to approve either a rule or a fee change that are incorporated in the schedule of charges and deadlines. So the first item I want to highlight is law corporation and LLP renewal application deadlines. This particular change is asking to set October 2nd as a deadline after which late fees will be assessed, and then 60 days thereafter following the notice of delinquency for the deadlines for law corporations or LLPs to submit their applications before they get suspended. So this is one of the changes it's relatively minor changes that we're putting forth in this schedule of charges and deadlines. There will be an item 6.14 in the regularly scheduled board meeting that has to do with legal specialization fees. It is a new fee that is being proposed. We are asking for authorization to apply a new non-compliance fees to the legal specialization program, and that's for any of those specialists who fail to timely complete and report their continuing legal education. And then the last item I want to highlight is the updates to mandatory fee arbitration fees. Item 6.13 in the board agenda has a little bit of amendments to the rules. It does include a new fee mediator compensation rate, and then a simplified fee schedule. So the structure of the MFA fees are changed, but these two items, 6.14 and 6.13, are going to be taken up and discussed in more detail at the board meeting. And the resolutions in this particular agenda item do specifically note that, should the board not approve them, things in the schedule of charges or these particular areas in the schedule of charges will revert back to what they were. And I think that's all I wanted to highlight on this agenda item. If there's any questions or.
Any questions or comments on the schedule of fees? Araceli, just so I'm clear, we're going to approve, if the motion carries to approve this, we still have to wait to see what happens at the full board for the items that you mentioned.
Right. So, yes, and the resolutions, again, were drafted with help from the Office of General Counsel to ensure that if a different action were to happen and it does not get adopted, we will revert this schedule. Just because of the order in which it's going into, it's a little bit interesting. But this is also going to the board for full adoption.
Okay.
This schedule of charges and deadline.
Okay. And with that, I guess maybe I could go in reverse order and go Barahona and then Grande. If we good?
Yes, I'll move it.
I'll second.
Very good. And with that, Sam, you call the roll, please.
Barahona,
Aye.
Gore, not present. Grande,
Aye.
Trejo, not present. Sewell.
I'm an aye.
3 ayes, 0 nays. The motion carries.
I think that concludes all the business before the Finance Committee today. Thank you, Araceli, for the presentations. Thank you, Trustees Barahona and Grande. And I think we are good to adjourn. And then I think we will next be going into the full board meeting, which I think starts at 11. Is that correct? Okay, very good. Thank you so much.
Thank you, Ernie.
Live recording.
Good morning, everyone. Welcome to the meeting of the Board of Trustees of the California State Bar. It's November 20th, 2025, and I'd like to call the meeting to order. As a reminder, this meeting is being recorded. Board Secretary Sharon Lim, please call the roll.
Barahona,
Present.
Buenaventura,
Present.
Cisneros,
Here.
Good,
Here.
Orr, here, Grande,
Here.
Harrison,
Here.
Huser, not present, Giorgiello,
Here.
Soel,
Present.
Stevens, not present, Tony,
Present.
Trejo, not present. Chair, you have a quorum.
Thank you very much. Next on the agenda is the call for public comment. Before we begin public comment, I would like to remind everyone of some of the ground rules for speaking during this meeting. Under the Bagley-Keene Open Meeting Act, public comments must pertain to items that are on the agenda or be related to matters that are within the jurisdiction of this agency. Specifically, the board is the State Bar's governing body and is responsible for exercising oversight of the State Bar. The board, sitting as the Regulation and Discipline Committee, oversees the work of the attorney discipline system. Under the State Bar's policy regarding public comment, members of the public cannot cede their time to another speaker. Any attempts to deceive the board by disguising your voice, using different aliases or names to participate in public comment or accent is, by extension, not allowed, as well as impermissible under the State Bar's policy against disruptive and/or disorderly conduct that may result in removal from the meeting. We appreciate your cooperation in maintaining a respectful and orderly environment for all attendees. State Bar staff will attempt to call members of the public in the order that they appear in the attendee pool. For those who are participating by Zoom video, you should have a function for virtually raising your hand. It is a hand icon that should appear at the bottom center of your screen. If you wish to address the board, please click on the hand icon now, and State Bar staff will call on you in the order that the hands are raised. For those who are participating by phone, you may virtually raise your hand by pressing *9. That is the star key, then number 9. Doing so will alert staff that you would like to make a comment, and State Bar staff will call on you and open your microphone so that you can address the board. For those who are participating from a noticed location, please alert the State Bar staff member present in the room that you would like to make a comment. Due to time restrictions, we cannot allow more than 2 minutes for each speaker. Please note that staff will have an on-screen countdown timer visible to all attendees during the duration of your public comment. The timer's 2-minute countdown will begin as soon as you start your comment, and the on-screen timer will flash through the final 10 seconds. So first, Sharon, let's see if trustees have any members at their locations, members of the public that would like to make a comment.
And we'll start with Trustee Harrison.
Yes, we have Kai on here.
Thank you. Kai, please begin your public comment.
Good morning, all trustees. My name is Kai On from Sacramento. I'm here again about my complaint against Sacramento DA, Mr. TNO, and Attorney General about my father, Woon Kong on staff. State Bar still refusing to review the DA case file 99F08735 to confirm my father, Woon Kong On, was the victim in the case, and Jun So Fong was the driver that killed my father with hit and run. State Bar asked me to go to the court to review the DA case file. It's not fair for a regular citizen to review a DA case file. It is the responsibility for State Bar to review the file to confirm the information that Jung So Fong was the driver that hit and run killed my father Woon Kong On in the case DA99F08735. I don't know why State Bar keep asking me to do it myself. This is the responsibility for the complaint unit to investigate, to verify the information. If the DA office and Sacramento police provide me fake information, but DA Mr. Tien Ho and Attorney General Mr. Robert Bronter had not taken any action to investigate since January 2024. Please look into the issue and take action against the complaint review unit. Thank you.
Thank you for your public comment. I do want to confirm if any other trustees have members of the public at their respective locations.
There's no members of the public here in San Francisco.
Thank you. We will move on to the advanced signups. And first we have Benjamin Cohn. Your mic has been enabled.
Hello, thank you. I wanted to address multiple items on the agenda today. The first one I wanted to address for the benefit of those not on the subcommittees is item 6.1, which I believe gives the board a vehicle to discuss, at the very least, the HUMRO report that staff is not singularly agendizing for board action. The board had discussed in May 2025 the need to provide remedies to those who Measure did not implement their approved testing accommodations in February 2025, which the staff have chosen to deem closed without any remedy whatsoever, based on their ability to recommend and elicit a CBE recommendation from a divided CBE on that issue without the board's input. But you have, under Bagley-Keene, the option to ask questions and discuss that for when they reach the updates from the Office of Admissions. And for the reasons in my written comment, the reasoning of the CBE fails to justify providing no remedy, and the board should take action. The next item I wanted to address is the fee increase proposal, which is relatedly on the consent calendar. You're asked to also approve the second round of raises and MOU expansions beyond those that were already required by MOUs for admissions staff. Since the February 2025 bar exam fiasco and all the notice that you would need to do things like pay for both Kaplan and NCBE and all the other financial stresses that have been used to justify the fee increases, despite knowing about all those financial challenges, if you approve that leave that on the consent calendar, the staff will have gotten 2 MOU expansions since then and raises on top of those they were already approved for. I believe that when they say these fee increases are necessary to avoid insolvency in the admissions fund, they're presupposing certain policy premises that really should be debated fully when deciding whether to raise fees, including that one. And the third item that I wanted to address is the Next Gen versus Nevada and the California specific bar exam. The NCBE has been taking the position that the state bar can't individually consider certain testing accommodations like remote testing, and it would make no sense to lock them in further when they are already causing considerable legal issue. Thank you.
Thank you for your public comment. I did just want to note for the record that Trustee Stevens is here. Next, we have Laura Riley. Your mic has been enabled.
Great. Good morning, members of the board. I'm Laura Riley, Assistant Dean of Clinical Education at UC Berkeley Law, and I'm speaking in my individual capacity. I am one of the over a dozen law school clinical and field placement department heads and faculty who jointly submitted a letter in opposition to the significant proposed increase in fees for the practical training of law students program, which is agenda item 6.2 in your meeting today. I wanted to highlight 3 areas that support maintaining the fees as they are now. First, an increase goes against the state bar mission. Second, the timing of this is particularly poor for students. And third, the fee as it is, and certainly would be with an increase, is out of step from other bar associations. So I'll revisit those 3 points. The State Bar's mission, as you know, is to advance the ethical and competent practice of law in support of efforts for greater access to and inclusion in the legal system. Erecting an additional financial burden for students to participate in PTLS creates disincentives for students from participating in the aspects of their legal education that best prepare them to practice under structured supervision, which ensures their competency when they join the bar. This disincentive also has the impact of making it more burdensome to provide the legal services work that they do provide as part of their clinics and as part of their field placement work that help give Californians access to the legal system. Second, the timing of this being particularly poor is that the state bar's own access to justice gaps study demonstrates that the justice gap is large and at risk of growing. Students who participate in the PTLS program are serving clients and are directly helping to narrow that gap, often serving people who are low-income clients throughout the state. Also, students starting next summer are going to be up against federal loan caps that will make it increasingly harder to enter the profession. And these additional fees create an additional burden for them as part of that financial burden. And third, with some initial research, they're out of step from other bars. Looking at the top 10 states that are graduates practice them, 7 of them do not charge fees for students to practice, and the 2 that do are lower than the current one that California charges. So with that, I respectfully request that the state bar decline to increase the fees for PTLS.
Thank you for your public comment. Next, we have Rebecca Oyama. Your mic has been enabled.
Hello there. Thank you so much for the opportunity to speak. My name is Rebecca Oyama. I'm the clinical director at the East Bay Community Law Center. We are a clinical program of UC Berkeley Law School. And for the last nearly 4 decades, the East Bay Community Law Center has been training our students under close hands-on supervision of their supervising attorneys. And I'm here to speak and urge the board to decline the proposed increase to the practical training of law students fee. At EBCLC, we offer critical legal services such as defending tenants from eviction, preventing harmful deportation of immigrant clients, keeping youth out of incarceration through representation in juvenile court, and many, many other services that our clients may not be able to access elsewhere. For our students, appearing in court is incredibly impactful, and not only for their learning experience, but also for their understanding of client relationships, of strategic decision-making, and many, many other transferable skills that they will need in their future careers. And our students regularly tell us that their time with our clinics and representing our clients in court has often been the most meaningful and practical training they've experienced in their law school career, and that these skills served them as they went on into their next paths in their law careers. We are currently facing a nearly impossible situation for students who do not enter law school with existing wealth. As Laura mentioned, the incoming loan caps by the federal government will be greatly impacting the affordability of law school. And under the current fee, our students, many of who are first generation to go to college, let alone graduate level school, are expected to pay $215 to be certified. With this proposed increase, they would be expecting to pay $300 out of pocket for the opportunity to appear on the record and represent clients. And many of our students are public interest students who are living on the equivalent of a $50,000 annual income for all of their expenses. And so as we've mentioned, there are many inequities that the proposed fee may in fact continue to perpetuate, including between our own law students and the experiences they receive. Thank you very much.
Next, we have Ikram Chaudhry, who I do not see in the attendee list. Next, we have Henri. Your mic has been enabled.
Yes, good morning. Can you hear me?
Yes, we can.
Thank you. I just wanted to speak on, I believe it's the Committee on Disciplinary stuff, item number 3.132. One of the things I wanted to talk about is the duty of the body to go forward and seriously investigate the complaints that people bring forward, and not only that, but at the very least, follow up with complainants. I've had an issue with several other complaints I brought forward. I don't get notified up until at some point the complaint is just closed out, where I'm never actually contacted for further discovery evidence for a complaint I submitted. But one of the more recent complaints actually has to do with an attorney who tried to unlawfully and via intimidation actually kick me out of an open courtroom where I was there to provide a victim impact statement. Contacted the prosecutors for a defendant that they were representing at the time. They no longer are. And they try to get the bailiff to actually kick me out of the room via their authority as an attorney. And the bailiff, who had actually spoken to prior at the start of the hearing, I told him that this might very well happen and keep an eye on it. And just to know that I contacted the prosecutors to be there. I'm talking about attorney Scott Ronald Spindell, number 2000817. And I do hope you take it seriously. There's quite a number of testimony you can get from the bailiff, from the prosecutors, from myself. All this conduct was done in open court to intimidate a witness that was key in providing material evidence to revoke the bail of the defendant that they were representing at the time. And this, I can't believe that this behavior is a one-off. From other people I've heard at the time of other similar open court hearings, apparently Scott Ronald Spindell tries similar tactics to
For your
intimidate
public
witnesses.
comment, but your time has concluded. Next, we have Edmund Arufo. Your mic has been enabled.
Yes, good morning. My name is Edmund Rufo. I'm a California licensed attorney, and I also have a bar prep program where I see about 1,000 students every year. I'm reiterating my previous comments in the proper forum. What I said previously is $150 isn't just $150 of a fee increase. It's 150 more. It's 150 more that's piling on to the exorbitant price that these candidates have to pay to join our profession. Today's candidates don't need one more bill. Anyone that watches the news or buys eggs, for that matter, knows that. Many of them are breadwinners. They can't work until they obtain their license. They're carrying their families, and they're carrying tremendous law school loans until they can pass the exam. This is a poll tax, plain and simple, and we're disproportionately excluding candidates who can't afford these increases. If $150 is so small of a fee to be added on to these fee increases, why can't we find a place to cut it out of the current budget? Every government organization is always hurting for money. I know that, but every government agency can also find a spot in their budget. For example, despite what happened in February, which by all accounts was a debacle, the October 2020 exam was conducted remotely, and it worked just fine. Were there glitches? There were, but we know that those sorts of things can happen. It's a game changer. It allows a greater participation, which brings more people to take the California bar exam, many from overseas, and it doesn't have the cost of testing centers and proctors associated with it. If California chooses to be a follower, please follow New York. Look up their bar fees, which are significantly less than ours. Considering that California and New York are probably the crown jewels of bar licenses within the United States, we can do better. New York chooses to use their budget not to make the exam too expensive for their bar candidates. California can choose to do the same. Thank you for your time.
Thank you for your public comment. Next, we have Shannon Quinley. Your mic has been enabled.
Good morning, trustees. My name is Shannon Quinley, representing the California Lawyers Association Family Law Executive Committee, known as FlexCom. I'm here to address the proposed amendment to Rule 7.3 of the Rules of Professional Conduct relating to solicitation of clients. Members of FlexCom include attorneys who represent petitioners, respondents, and children in domestic violence restraining order proceedings, and who sit as temporary judges hearing those proceedings. We have extensive experience with such matters, which are often complex and emotionally charged. This proposal appears to be aimed at the problem of cold solicitations from attorneys who troll the dockets in search of potential clients. We agree this conduct should be prohibited as it relates to domestic violence cases because of the increased risk to the safety of the petitioner. However, the proposed amendment is not narrowly tailored to address the identified problem because it fails to draw a clear distinction between attorneys engaged in cold solicitation of respondents and attorneys who have a prior existing relationship with the respondent. Flexcom is unaware of any evidence showing that attorneys contacting a respondent who is a former or current client contribute to the identified problems. This amendment would prevent us from speaking about a public record without adequate justification and impede a key part of our work, de-escalating conflict. Early attorney involvement is critical. In domestic violence cases, it is preferable for respondents to learn about restraining orders from their attorney or prior attorney before service, as service itself can provoke strong reactions and escalate conflict or violence. Discussing the order, its consequences, and possible solutions with their trusted advisor helps reduce that risk. For these reasons, Flexcom respectfully requests that the proposal be amended to provide that it does not apply when the unserved respondent is the lawyer's former or current client. Thank you.
Next, we have Claire. Your mic has been enabled.
Good morning. This is Claire Solat from the Legal Services Funders Network. I'm going to be commenting today on the two items relating to proposed fee increases. First, with regards to the PTLS, there's inconsistent information that as to whether the current fee actually does cover the state bar costs. The proposed increase of 142% will be borne by law students, LSO hosts, and/or law schools. While the total dollar amount per person may seem small, for law students who must pay it for themselves, the increase is significant. For law schools and LSOs that host these law students, it could result in thousands of additional dollars added to their budgets every year. Moving on to the registered legal aid attorney provision, the proposed 46% increase will be a hardship for many legal service organizations. It is unclear why RLAAs should pay more than 20% more for annual license fees than for other attorneys. It's also unclear, while this fee is being proposed to go up, the military spouse fee is being proposed to be zeroed out. Both the PTLS and the RLAA programs fulfill the bar's mission to help serve the public. Both programs result in attorneys who have lower misconduct and discipline rates than the attorney population as a whole. I urge the State Bar to consider whether the two factors I just mentioned warrant considering using some of the State Bar's general funds to help cover these program costs, as the benefits support other State Bar activities and goals. In addition, there's the opportunity to explore public-private partnerships to help cover these costs. As the leading legal service private funder in this state and as the head of the LSFN, I have yet to be contacted about this opportunity, but I welcome the State Bar reaching out to me. Thank you so much.
Thank you for your public comment. Next, we have Jules Sarkar. Your mic has been enabled.
Good morning. My name is Jules Sarkar. I'm an attorney in California. I represent attorney applicants against the State Bar of California. I'm here today to oppose agenda items number 6.2 and 6.3. I'll start with opposing the adoption of the NCBE's Next Gen Bar exam, in addition to the fact that all of the NCBE's own studies show that all of the exams that it's developed are not valid, don't serve valid purpose, and that's why the NCBE's attorneys aren't willing to sit for their own exam and skip that exam under the diploma privilege. I remind the State Bar that the State Bar has facilitated the NCBE's violation of our state's government conflict of interest laws under Government Code Section 1090. The only reason they haven't been prosecuted by the Fair Political Practices Commission yet is because the contract hasn't been granted. So when the NCBE does obtain that contract, that will complete the violation of Section 1090, and that will make the violation ripe for prosecution. I urge the State Bar to not to discontinue and not provide any more contracts to the NCBE. With respect to the proposed fee increases, basically what the admissions employees are telling you is that the annual year-end financial statements that the State Bar has been producing so far, certified under oath, are false. What the State Bar has published and provided to the Supreme Court, to our legislature and the public, states that the State Bar took over $25 million in exam fees from applicants, and the expenses totaled under $7 million. If you do the math, that's about $18 million in profits. And the year before that, they received over $18 million in fees from applicants, and they spent under $8 million.
Thank you for your public comment, but your time has concluded. Next, we have Sandy Flagg Phillips. Your mic has been enabled.
Hello, can you hear me? I think I'm coming through. Hello, I address the board today as a current Jenny Commissioner and also as the Commission's incoming Vice Chair. I wish to express my gratitude to the State Bar for temporarily pausing its proposal to cancel the Jenny Commission's Saturday meeting schedule. Future scheduling decisions will likely take place during my tenure as Chair of the Commission, and so I and many others have a vested interest in matters affecting the Commission's future diversity and ability to carry out our statutory charge. I and other Jenny stakeholders value advance notice of any planned operational changes so that we can continue to work together on equitable solutions for our organization. Thank you.
Thank you. Next, we have Lorena Peñalosa. Your mic has been enabled.
Can you hear me?
Yes, we can.
Hello? Okay, thank you. Good morning, esteemed trustees and State Bar staff. My name is Lorena Peñalosa. I apologize for being unable to appear in person. I am the current chair of the Jenny Commission, and while I come to speak to you about Jenny, I do so in my personal capacity. First, I want to extend a warm welcome to new Executive Director Laura Enderton-Speed. Congratulations on this new role. As a member of the Bar, I'm excited to learn about your vision, and I look forward to working with you closely in my remaining months as Jenny Chair. As a member of the Bar, I care about the work the Jenny Commission does, consistent with its regulatory framework. Jenny has gone through many changes in recent years, and it appears the Commission is poised to experience more potential changes even beyond my term. To better inform potential future changes, I have put together a small task force of current and past Jenny members, including leadership, to gather input from current and former members to encourage and improve dialogue between Jenny, State Bar leadership, and the board. The task force also seeks to improve the way we gather information and input from Jenny commissioners who have been and are steeped in this important work to better inform State Bar leadership and the board prior to considering any future changes. My personal hope is the task force will live well beyond my term. This effort has already proved fruitful. We are currently working with State Bar leadership on tools to collect comments and feedback regarding potential changes currently being considered to Jenny meetings arising from the approval of the State Bar MOU in July. I hope to return in the near future in my capacity as chair with fellow task force members to share the results of those efforts. To that end, I want to personally thank and express my profound gratitude to Program Director for the Office of Access and Inclusion, Elizabeth Holm, former Interim Executive Director, Erica Doherty, Chair Cisneros, and this board for the grace and flexibility you have demonstrated in postponing any changes to Jenny meetings through December 2026. Thank you for understanding and valuing the time and collaborative approach essential to ensuring Jenny meets its statutory obligations and maintains the high standards of the important work it carries out in the judicial appointment process. Thank you.
Thank you. Next, we have Nicole Lawton Balls. Your mic has been enabled.
Can you hear me? Can you hear me?
Yes, we can.
I'm sorry, I'm at work. I apologize. I'm a Purdue Global Law student, and I'm in my third to last semester. And I also have a disability, which prevented me from going to a brick and mortar law school. And I was studying and looking into the bar and everything. And being that a disabled student like myself, it's difficult for us to get to California and have to pay all the fees. So raising the fees makes a disadvantage for me because I want to work to help people. I want to work to help homeless people. I want to work to help disabled people. And the fees are extremely expensive for me. And also I wanted to talk about is it possible for the Cal Bar would think about doing a diploma privilege for all the Cal Bar law schools? Wisconsin has a program that if you graduate from one of their law schools, which is two of them that they have, you automatically will be accepted to the bar so you can start working. I think California needs to do that because there's a lot of people in need that need attorneys and that's willing to do pro bono work, that's willing to do legal aid work. And there's only a handful of schools that are California certified that are not ABA certified. We should have some type of leniency to not have to take the bar, be admitted on diploma privileges. So I would wish that you would think about that because we work very hard to go to school, to try to afford it, and to want to help people. Right now I work for the City of New York Department of Homeless Services, and there's people here and in California that are struggling, that cannot find a place to live and don't have anything. And we need to do something about that. Making it harder for lawyers to go to work or students to become a lawyer is not good. That's all I have to say.
Thank you for your public comment. Next, we have Stella Nye. Your mic has been enabled.
Hi there, this is Stella Nye. I am I was the 2021 Jenny Chair, and thank you for hearing me today. I want to thank the board and Interim Director Ms. Doherty for putting a pause on changes to the Jenny Commission through December 2026. I also want to thank Elizabeth Hom for facilitating the Chair's task force in discussing potential changes to Jenny. I know you have a lot on your plates, and I really appreciate the fruitful discussion and for you taking our input. And like the other members of the task force, I very much hope that you keep us apprised of contemplated changes to any Jenny operations. So that would be any Jenny operations, not just things that would go to the board. So thank you very much, and thank you very much for your work with our exciting profession, the legal profession.
Thank you for your public comment. Chair, we do not have any more raised hands or public commenters.
All right. Thank you very much. With that, we'll close public comment. Next on the agenda is the chair's report. I would just like to announce that the trustee liaison appointments and the the 6-meeting Board of Trustees meeting schedule for the coming year 2026 are both posted to the agenda of this meeting. And now it is my honor to invite our new executive director to give her first executive director's report. Laura.
Thank you, Chair Cisneros and board members. I will keep this short. We have a very packed agenda today. I first want to, again, express my gratitude to the Board of Trustees for the trust you placed in me in selecting me. This is my third week on the job, my first official board meeting, and I look forward to working closely with you and our justice partners and our stakeholders. Many of you heard when we were in interviews and through selections that I prioritize collaboration, impartiality, transparency, and accountability, and I want to keep all of those in mind as we move forward and collaborate with the board, with the Committee of Bar Examiners, any of our sub-entities, and our staff. Again, honored to be here, and as I said, we have a very full agenda for the next couple days, so with that, happy to move on to the next item. Thank you.
Thank you, our executive director. Moving on to our approval of open session minutes from the joint meeting with the Committee of Bar Examiners dated August 14th, 2025. Do I hear any comments or a motion?
I have a question. And has the change been made that I asked about on the, so the meeting is a joint meeting, right? Of the Board of Trustees and the Committee of Bar Examiners. So it says the time meeting commenced, the board meeting commenced in open session at 9:05. Did the Committee of Bar Examiners have a separate meeting, or was this the joint meeting? Because it says that, later, the next sentence is the board moved into a joint closed session with the Committee of Bar Examiners. So I recall that we had a meeting together with the Committee of Bar Examiners.
Yes, we moved together, the board and the committee moved together into closed session, and there's a few items.
But did we open together in open session?
Correct.
So the minutes need to be revised to say the joint Board of Trustees and Committee of Bar Examiner meetings commenced in open session at 9:05. Is that accurate or not?
That sounds accurate, correct.
Okay.
Yep.
Then I would like that addition to be made. That's my only addition that I would like made. It just makes it more clear to somebody reading this 5 years from now.
That makes sense.
Do I hear a motion?
I'll move adoption of the minutes with the amendment I requested.
Okay. Motion by trustee Tony, second by trustee Gore. Vote, please.
Barahona?
Aye.
Buenaventura?
Aye.
Good?
Abstain as I was not present.
Orr?
Aye.
Grande?
Aye.
Harrison? Harrison? Oh, maybe it's.
Can't hear him.
Oh, I think it's an aye. Nod your head. Yes, okay. Huser, not present. Giorgiello?
Abstain is not present at the meeting.
Sowell?
Aye.
Stevens?
Aye.
Tony?
Aye.
Trejo, not present. Cisneros?
Aye.
With 9 ayes and 0 nays, the minutes are adopted.
Great. Next item is approval of the September 18th and 19th, 2025 Board of Trustees open session minutes. Any changes or comments or a motion?
I would move to approve.
I need to look to see if the changes I had requested got added. Give me half a second.
Chair, if I may. Trustee Tony, those amendments have been made as we had previously discussed.
Okay, thank you. I appreciate it.
Motion by Stevens. Do I hear a second? Was that Harrison?
Yes.
Thank you. Motion by Stevens, second by trustee Harrison. Vote, please.
Barahona?
Aye.
Buenaventura?
Aye.
Good?
Aye.
Gore?
Aye.
Grande?
Aye.
Harrison?
Aye.
User, not present. Giorgiello?
Abstain is not present on the 18th.
Sowell?
Aye.
Stevens?
Aye.
Tony?
Aye.
Trejo, not present. Cisneros?
Aye.
With 10 ayes and 0 nays, the minutes are adopted.
Thank you very much. We'll now move on to the consent calendar. If there are any member wishes to pull any items off the consent calendar, please do so now. If not, we'll consider the combined set of items. Any questions or a motion?
Chair Cisneros, I'll move the consent calendar.
Thank you, Trustee Sowell. Do I hear a second?
Second.
All right. Motion by Trustee Sowell. First second was by Trustee Gore. Thank you very much, Trustee Stevens. Vote, please.
Barahona,
Aye.
Buenaventura,
Aye.
Good,
Aye.
Gore, aye. Grande,
Aye.
Harrison, Huser, not present. Jargiello,
Aye.
Sowell,
Aye.
Stevens,
Aye.
Tony,
Aye.
Trejo, not present. Cisneros,
Aye.
with 11 ayes and 0 nays, the motion carries.
Thank you very much.
Can you hear me?
You're very faint, Trustee Harrison.
All right, thank you.
That was better. All right, next on the agenda is the 2025 Annual Discipline Report Review and Approval. This item is being presented by the Program Director, Kulan Erdenanabatar, from the Office of Research and Statistics, and Chief Trial Counsel, George Cardona. We're still waiting for Kulan. Welcome, Kulan. Please go ahead.
Thank you. Good afternoon, trustees. I'm here to present highlights from the 2025 Annual Discipline Report with our Chief Trial Counsel, George Cardona. Let me share my screen. I hope everyone can see that.
Yes, we can.
Great, thanks. So before I start, I want to thank the ORS team who produced this 89-page report this year. Jorge Matachoa, Josiah Sweeting, and Jens Zeschke. Thank you. Okay. I'll start with some background on the annual discipline report, or the ADR, for our newer trustees. The report is required by the Business and Professions Code. The State Bar must report on the performance and condition of the attorney discipline system each year to the legislature. And as you know, the discipline system includes OCTC as well as the State Bar Court and Office of Probation. But the ADR primarily focuses on OCTC, who receives, investigates, and when appropriate, prosecutes alleged misconduct. The statute specifies about a dozen metrics that are listed here, from case inventory to cost of the discipline system. It also includes several other metrics that are required by other statutes that are also listed on this slide. The report is fiscal year based, and it's due to the legislature by November 30th of every year. So at the end of this presentation, we'll ask you to approve the submission of the report to the legislature. The report has three main sections. The first section is the narrative, and this is where we describe performance highlights and provide additional context to the numbers. And this is also where we report demographics data for disciplined attorneys. So if you don't have time to read all 89 pages, this is the section to read. It's also only 14 pages. The next section is the statutory tables. There are 15 of them, and they contain all the required data. And the last section are the appendices. It includes glossary, glossary, methodology, overview of the attorney discipline system, as well as data on the potential conflict of interest cases and the diversion program data. The diversion program was launched in 2023, and we added this appendix last year. This structure we try to keep the same every year. It makes it easier to compare from year to year, and we don't get questioned about changes to the report. That said, we did make two changes this year. The first one is how we define case complexity, and George will talk about it more. And the other one had to do with client security fund payment reporting. We used to report individual payments, which took up 27 pages and was above and beyond what the statute requires. So now we only provide a summary table. And the last bit of context I want to add is the connection between the ADR and the CTC dashboard. The key metrics that you see in the ADR, the same ones that you see on the CTC dashboard that George presents to you every quarter. And these metrics are number of cases open, closed, pending cases, and case processing speed. So with that, I will turn it over to Mr. Cardona.
Thanks. If we can move to the next slide, that would be great. So here's the case volume, and you can see a trend among cases being opened. There's been an increase. 2025 marked the third consecutive year, and the rate of increase in incoming cases has been accelerating. In fiscal year 2025, state fiscal year 2025, we opened 21,205 new matters. That's up 17% from FY 2024, and as you can see, it's even higher than it was in 2020, which was the last kind of pre-pandemic year. On the bottom, you can see that we've also increased the number of cases we get through and process to either closure or resolution each year. But as you can also see, the increase in the number of cases we've closed, even though it's significant, has not kept up with the increase in incoming cases. So if we can go to the next slide. The predictable result of this is that despite our best efforts to increase our numbers of case closures and so decrease our inventory, which has been one of our goals, you can see that in fiscal year 2024, we accomplished for the first time a reduction in our inventory at year end. This year, we had a target to accomplish the same thing, but because of the rather drastic increase in the number of incoming cases, we are not going to accomplish that. And you'll see that, in fact, the inventory at the end of fiscal year 2025 actually increased as a result of the accelerated increase in the number of cases coming in. We'll talk about this in a little bit more detail when we go through the OCTC dashboard with the quarterly statistics to kind of look at some trends and see what we can see there. But with that, if we can go to the next slide. This is the case processing time. You can see that on the bottom line, which is the cases on the bottom line, you can see that on average we took 131 days to resolve a case, basically the same as in fiscal year 2024. The trend here that is disturbing is the trend shown in the top line, where you can see the average case time, processing time in OCTC for cases that we ultimately file in the state bar court. You can see that that's been on an upward trend. Some of that may be attributable to our effort to try and resolve and file the older cases out of our inventory. And as we'll see when we look at the OCTC dashboard, our inventory distribution has changed. We have reduced significantly the percentage of older cases in our inventory. And that may be in part be driving that, but this is something that we're going to continue to look at and try and bring that number down. You can also see that the average age of pending cases, which is the middle line, has been decreasing, and it has actually gone down to 284 days. Again, that's reflective of the change in our case inventory and our trying to get rid of some of the older cases that are still pending in that inventory. So if we can go to the next slide. This is our performance as measured by the case processing goals, the current statutory case processing goals, which are 180 days for non-complex cases and 12 months for complex cases. You can see that while there have been fluctuations, generally we have been on an upward trend here, which is good. In other words, we've been closing more cases within those statutory guidelines. Coulon had referenced a change in the complexity definition. As we were going through the data this year, we discovered that the definition that we were using for complexity in the ADR did not match what we were using as the definition for complexity in the OCTC dashboard. And in particular, we were including as complex cases for purposes of the ADR some cases that met certain criteria for being complex, but nevertheless were resolved in intake, that is at our first stage. In the OCTC dashboard, we did not include those on the theory that any case that was capable of being resolved in intake within a relatively short period of time should not be treated as a complex case. So we've now adopted that definition for the ADR as well and adjusted the statistics backwards to reflect that so that it's accurately comparable across all the years. With those changes, basically there was a reduction in the number of complex cases, an increase in the number of complex cases. The overall figures are essentially the same, and so the trends are still something that we can rely on. And you can see that we're now closing 86% of our total cases within case closing guidelines, 92% for non-complex cases and 68% for complex cases, showing that our failure to meet the case processing goals is essentially attributable to our more complex cases, which are taking longer to handle. So with that, if we can turn to the next slide. Another thing that we look at are bank reportable actions. These are reports to us from financial institutions when a client trust account engages in an insufficient funds transaction. Here you can see a significant drop in cases received from FY 2020 to the present with fluctuations, but a significant drop. We believe that this decline is the result of preventative efforts by both our office and the Department of Regulation, and in particular the launch of the Client Trust Account Protection Program. That was launched in 2023, and its reporting requirements and practical record-keeping training, along with similar efforts at prevention and advising attorneys about requirements to maintain their client trust accounts by OCTC, likely have increased attorney awareness and compliance, reducing the number of cases we're seeing in that. Along with that, we've seen a reduction or an alteration in the disposition pattern. for bank reportable actions. It's been shifting from no action resolutions, that is simply a closure. Oh, if we can go to the next slide, sorry. Simply a closure with nothing to more non-disciplinary resolutions. There are likely two policy changes that are driving this. First, for all client trust account cases now, including bank reportable actions, our office sends out a resource letter, which is one of the preventative measures to advise attorneys of the requirements for handling client trust accounts and provide them with links to resources. And second, we also resolve a significant number of these with our diversion program. And so those are two things that are altering the mix of dispositions. So those are kind of the highlighted things that are outlined in the ADR. And with that, I'll turn it back to Kulan, who's going to talk about some of the demographic data that's included in the ADR.
Thanks, George. So now I'll walk you through this year's demographics of disciplined attorney data, but I'll start with some context again. We began reporting demographics in the ADR in 2023. It's not required by a statute. It comes from our strategic plan. And one of the reasons for this addition was the 2019 disparity study, also known as the Farkas study. And this study done by Dr. Farkas found that Black and Latino attorneys were more likely to be investigated and disciplined than their white counterparts. And that gap, that disparity came down to four main factors: prior discipline, lack of counsel, reportable actions, and number of prior complaints and investigations. So this year, as some of you may remember, we published a 5-year update to this original study. And this year's study was done by another researcher, Dr. Stixrud, and her main finding was that disparity overall have narrowed compared to the 2019 study, the baseline. After she controlled for factors like case characteristics and counsel representation, prior discipline, the gap in disbarment almost disappeared, though Black and Latino men are more likely to receive a probation. So now back to this year's ADR data. We only show a single year snapshot of demographics data. And this year, 154 attorneys were disciplined, 69 were disbarred, 69 got probation, and 16 got reprovals. Last year's total was 229. So before I show the breakdown by gender and race, I just want to caution that the small numbers can create noise. The disciplined attorney pool is small, and when we divide it by gender and race, the slices get even tinier. So keep that in mind. And actually, this is why we do robust and multi-year studies like the disparity study to identify real trends. So let's move on to the race data. In 2025, the table here shows the discipline number of attorneys for each race group. And the table on the right shows a comparison of that group's share in discipline against their share in the active attorney population. And just for context, we have about 200,000 active attorneys right now. So what jumps out here is Hispanic and Latino attorneys' representation in discipline is much higher than their active attorney representation. Hispanic and Latino attorneys made about 14% of those who disciplined, but only 6% of the active attorney population. And this, of course, is a potentially concerning figure, but I do want to point out that the 14% comes from 21 attorneys, which is 3 more than last year's. And last year, Hispanic and Latino attorneys representation in discipline was 7%. So this is why I was cautioning about small numbers. Small changes can create big swings in percentages. And actually, for next year, we are proposing to add multi-year data in the ADR so we can provide better context. In terms of gender, the trend has been consistent, much more consistent over the years. Men get disciplined at much higher rate than women. This year, men made up 77% of those who disciplined, but they're 54% of the active attorney population. And this gap shows up in every discipline type. So unlike the race data, the gender gap we see is a real and persistent pattern. So that is that's the 2025 ADR. George and I can take any questions.
Thank you very much. Any questions from trustees? I see a raised hand in San Francisco, as well as with Cynthia. San Francisco, go ahead.
I'll let David go first.
Oh, I just had a question. Why are complaints up? Is there a reason for that?
We've actually been looking at that to see if we can identify any good reason for why they're increasing at the rate they are. So far, we haven't been able to identify any particular trend that would seem to explain it. We just seem to be seeing a lot of complaints. We have been seeing a lot of individual complainants who are filing multiple complaints against multiple attorneys, which is part of it. We have also started to see some number of complaints that appear to be generated using AI, which may also contribute to it. But we haven't really been able to identify anything that we could point to as clearly explaining that trend.
And there's no specific types of complaints that are more, there's no trends within the body of, there's no, okay, got it.
No, we've looked at that to see if there's any particular charge that's driving it, but we haven't identified anything that would be along those lines.
Got it. Thank you.
And George, I presume that that's with respect to the substantive practice area at issue as well.
So far, that's correct. We haven't identified any substantive practice area that appears to be disproportionately driving the increase in complaints.
So I had a comment, which is, first of all, George, I commend you and your team for doing such an incredible job, frankly. You're asked to do more with less resources. This uptick of 17% over a prior year uptick to 21,000 cases a year is just extraordinary. So I commend you for doing more with less. However, for the other trustees and for anyone else listening, this underscores for me that we need to get you more resources and get you more OCTC attorneys. This is of critical importance to us in fulfilling our mission to protect the public, because this kind of growth is not sustainable. So I know we've asked for additional resources before from the legislature in our fee funding bill. This underscores that this is a top priority for us and one that we need to focus on. So I just want to underscore that. And then in addition, I am disturbed by the demographic trends. I recognize that it's a small population, But I'm sure that Mr. Cardona is going to keep a close watch on it, but I would suggest that we be updated maybe midway through next year to see where we're at and to see if we need to be doing anything in particular with respect to really material percentage increase in discipline cases against Hispanic and Latino attorneys, and if we need to maybe hire a consultant or focus on that. I recognize the data set is low. That comes with a lot of caveats, but I'm still disturbed by it, and I think it's something that we need to watch. Thank you.
Thank you, trustees. Now, Trustee Grande.
Thank you. And I echo Trustees Good's remarks about just the presentation and the work that goes into all of this. I think for me, I think the next question for me is looking at, I would want to know the breakdown of practice areas and then also firm size, whether it's a solo or a small firm, mid-sized firm, large firm, so that we can get a sense of, I think just those data points are useful and could inform what we could do on the preventative side, right, to make sure that there are resources that address the root of some of these issues that lead to discipline. So if we could incorporate that in the future, I would really appreciate it.
So those factors were included. We tried to take a look at those in the update to the FARCUS study that was done this year. There have been limitations on the available data on that perhaps Kulan could speak to. I think we do hope to look at that more in the future because we share your view that those might be part of the explanation that might guide things we can do. But maybe Kulan can speak to the data on those and the difficulties.
Yeah, so for practice area, the data quality, because it's not mandated field, the data quality is not great. But because of Rule 2.2, firm size in practice sector is a required field, and we have been getting good quality data for about a year. So I think in 2027 we should have enough data to produce another set of analysis.
Great, thank you.
Any other comments, Trustee Soal?
First of all, Kulan and George, thank you for the presentation. Just two quick questions from me. One is, am I understanding this correctly? That out of the approximately 200,000 attorneys that are in the state, only 154 were disciplined?
That's correct. We have roughly 190,000 active attorneys, and out of those, in fiscal year 2025, there were roughly 150.
Got it. So clearly a very, very sort of small percentage, but some disparities, obviously, in who is getting disciplined. But I just wanted to kind of wrap my head around what a small percentage of attorneys are actually being disciplined. It's nominal in the grand scheme of things.
Yeah, I mean, remember in prior presentations of that 21,000 in complaints, roughly 60% gets closed in intake. Roughly another 35% will be closed as a result of investigation, leaving approximately 4 to 5% that proceeds to the charging phase, out of which we generate that 159 that are charged. So there is kind of a funnel as the complaints come in.
Got it. Second, sort of building on Trustee Good's sort of commentary about staffing levels at OCTC. George, you may not have this off the top of your head, but over the period that's represented here, sort of this 5-year period, can you speak to staffing levels at OCTC and maybe average caseloads?
I don't have the data on average caseloads, although I can try and get that for the next meeting in connection with the strategic planning, perhaps. In terms of attorneys, there was an increase in OCTC staffing up until roughly 2023, 2024. Now, and in particular as of July 1st of this year, as a result of the State Bar's move overall towards a 15% vacancy rate, we have seen a decrease in staffing. I believe that right now OCTC, as compared to our number of positions as of the start of the fiscal year, is roughly at a 9 to 12% vacancy rate. So we're down positions there. So our staffing right now is decreasing as we move towards a 15% vacancy rate.
Okay, thank you.
Thank you. Trustee Barahona.
Thank you, Chair. I just had a question. Thank you, Kulan and George, for the information. You said that the increase could be, a portion of that increase was AI generated complaints. Do you have a sense of what percentage of that increase was AI generated, or?
I don't. We don't have a mechanism for definitively identifying what's been generated by AI. I'm basing that simply on anecdotal experience, looking at a number of complaints that have kind of common attributes for documents that are generated by AI. In other words, they use certain forms of common language. They have certain common formatting, which suggests that they've been generated by an AI engine, but we don't have definitive information as to whether in fact that's the case.
Yeah, I mean, I ask because I have some curiosity around any ways in which we may be able to receive some of those complaints through like an AI software that could either help expedite some of the processing. I know that you're thinking about this in a number of directions, but in addition to that, could get us more information. So I know that I'm just curious about that, George, on your end.
Yeah, we'll actually be doing a presentation later. There's both a closed session presentation and an open session presentation in which we'll be discussing some of the ways in which we're hoping to use AI to assist in making our initial processing of complaints potentially more efficient.
All right. Any other comments? Also keeping in mind this is an action item. We'll need a motion in a second.
I do. I just want to wait for other people.
Go right ahead.
Could we have back on screen the presentation? Because I want to refer to a couple of the slides, please.
Yes.
Thank you.
Which one?
So if we could go to the, it may be the first one. Okay. I'm sorry. Okay. Go further. Okay. This is a good one. So this is remarkable. The number of closed cases in 2025, that's a huge increase. And I want to make sure we recognize this, and because this is something that OCTC has control over, how many cases they close. And we also, I think it's important to be clear, OCTC has no control over how many complaints come in. Okay, that is external. And so I really want to make sure we focus on the success of the closed cases. And if it is, my suspicion is, I wonder whether that's a record setting. I only see back the years that are presented. But I wonder whether that's a record setting number of closed in 1 year. And if it is, I think it's worth pointing out. That's a large number.
I don't remember what the numbers are in prior years. We could obviously look back and see. I don't know, Kulan, if you know.
I don't know, but it could be a record because I don't remember. I think 2020 and 2019 were the highest numbers, and the previous years were lower. So it could really be the record number of cases.
And combined with Trustee Sowell's comment that this is with reduced staffing, it's worth pointing out that the efficiencies have clearly improved under George's tenure. Yes, George.
In fairness, the bulk of our staff reductions didn't occur until July 1st of this year as a result of the voluntary reduction in force. And this data only goes through June 30th of this year. So we'll have to wait for next year to see if there's really what the
Okay.
impacts of the significant staffing reductions are.
Thank you for that clarification. Appreciate it. So then my second point is if you would go one or two, I just don't remember which is which. No, one more.
Yeah.
Keep going. One more. One more. There's one more, the one after this. So my first question is, can you say what the difference between closed with no action and closed with non-disciplinary action? I just don't, maybe it was in here, I don't remember.
Yeah, it's not, but closed with
Okay.
no action is when we simply send a closing letter. We simply close it with no other action.
Okay.
Closed with some form of non-disciplinary action would include any of the non-disciplinary resolutions we can engage in. So a warning letter, a resource letter, diversion, all of which are non-disciplinary but are actions over and above just simply saying it's closed. So for example, a warning letter would advise them, we've reviewed it, we believe there's significant evidence of a violation of this. You're cautioned that you should correct your conduct to avoid this in the future.
And so do any of these reportable actions result in going to an investigation? You know what I'm trying to say?
So
I'm just curious.
typically our non-disciplinary actions, with the exception of diversion, we do diversion and intake before we move it to
Sure.
investigation. But the other non-disciplinary actions typically would be after the case has moved to investigation. The exception to that also is resource letters. We typically will issue a resource letter even if we close the case and intake without investigation.
I think this is very significant and a very positive sign that not only are we seeing the numbers go down, but what we're seeing here is OCTC being more involved and engaged with attorneys who get these letters. So I think this is outstanding, and I think it will contribute to the numbers going down. When attorneys receive a communication saying, hey, take care of this, look at this, we have some concerns, here's some suggestions. To me, the 44 number in gold is a good number. From my standpoint, that's how I interpret this. That's the meaning to me. Am I close? You feel?
Yes, I agree. I mean, I think this is part of what is driving down. On the previous slide, we saw a decrease in the number of bank reportable actions, and I think this is part of what's doing that, along with the Client Trust Account Protection Program. More proactive regulatory efforts.
Okay. Now, I have one recommendation for staff. It's completely discretion of staff, okay? I understand and appreciate how hard people have worked on this report, and I'm very pleased with it. I would just suggest consideration of a 2-page executive summary at the beginning that lists the key points of progress, which might include the closed cases, some of the bank reportable, maybe one or two other points. Innovation in process. I think it's useful for people to know what innovations George has brought in to yield, this increased efficiencies. That would be page 1. And page 2 would be some of the challenges. Increasing complaints. Those are not under the control, but it is a challenge. And resource constraints. Okay, talking about needing more resources. Trustee Good talked about that. And I think priorities for 2026. I think and the reason I say 2 pages is because you can print it on 2 sides of 1 page, and we can use it later throughout the year to distribute while we're up in the Capitol and stuff to people who may not be inclined to read the 66 pages, but might look at 2 pages. Those are my thoughts. I leave it up to staff whether they have the time or inclination.
Yes, Trustee Gore.
I'm going to try to knit together a couple of thoughts here with the staffing issues and as well as the extreme performance. I would want to know if that staff is getting burned out in any way. If that they're doing this extraordinary work because they're putting in super long hours or anything like that to make sure that we have a good perspective on what is the impact of accomplishing those extraordinary numbers.
That is a concern. We have been pushing hard for the last 2 years to increase the number of case resolutions each year to try and bring our inventory down. That is, ongoing morale in the office is of concern, particularly given the reduction in staff, and that's something we're going to try to address next year. We'll be tweaking our goals for next year to account for both the increase in cases and the reductions in staff in the hope of avoiding precisely what you're pointing at. We'll see how successful we are.
Because we might be on the other end of seeing folks go elsewhere or resignation, and so the percentage might grow due to other reasons. Yeah. So, no, I appreciate your candor in sharing that. You have been pushing, but also it does have a toll on the morale. So, thank you for achieving those numbers, and wanted the trustees to be aware of the potential impact.
Thank you. Any other comments? Or do we hear a motion in a second? And do we have a... Okay, San Francisco. Making a motion?
So moved.
Thank you.
I'll second.
Second by Harrison. Here is the language. Motion by Giorgello, second by Harrison. Roll call vote, please.
Barahona?
Aye.
Bonaventura?
Aye.
Good? Gore?
Aye.
Grande?
Aye.
Harrison?
Aye.
Huser not present. Giorgiello?
Aye.
Soel?
Aye.
Stevens?
Aye.
Tony?
Aye.
Trejo not present. Cisneros?
Aye.
With 11 ayes and 0 nays, the motion carries.
Thank you very much. Mr. Cardona, I believe the next item is yours as well.
It is. And, I think we're going to get a PowerPoint up. Okay, so we're going to report on our Q3 dashboard metrics. Quickly, since we've already covered some of this in discussing the ADR, I'm going to try and go through and just highlight some things from this. So first, we discussed some changes. There was another change based on some changes in our Odyssey coding. So in Odyssey, we flag certain cases in certain ways. There were some changes in some of those codes that also affected the complexity calculation. Again, it has minor effect on the absolute numbers as shown in the 2 graphs at the bottom, but not really any impact on the trends, which is what we try to focus on. So just wanted people to be aware of that. This is basically our overall caseload and inventory, and this essentially reflects the same thing, the increases in cases coming in and the impact that's had on our overall case closure rate. But what I wanted to highlight is in the bottom right graph, which shows basically our inventory, our total pending inventory and the makeup of that. The colors at the bottom, the 2 orange colors, are basically our older cases. The blue cases are the cases that are less than 180 days old. So you can see that from over the last 2 years, basically the makeup of our inventory has shifted. We've been reducing the older cases so that the majority of our inventory is now made up of the less old cases, which has been one of our targets. We will continue to focus on that. In particular, we're focused on trying to resolve or close or otherwise address the cases in our inventory that are more than 750 days old, which we have quite a number. We're continuing to focus on that. Our focus on that may have the impact of driving up the average age at closure as we resolve those older cases, but it will ultimately get us to a better point with respect to our overall inventory. So just wanted to make that point here. These are the backlog numbers for both cases pending in backlog and closed in backlog. This is consistent with the ADR numbers that we reported. So I'm not going to cover this at any length. If you remember in the last, in Q2 of 2025, at the suggestion of the state auditor in particular, we added standards for backlog based on our SB 211 proposed case processing standards. That's shown here. You can see the trends along the way. They have largely been consistent. I will note, if you look at the top graph, percentage of open cases in backlog status and percentage of cases closed in backlog status in our intake section, you can see that there was a gradual downward trend in that, except for the last quarter, where that has now gone up. We believe that's a direct result of the increase in the inventory as we've gotten cases coming in, which has taxed our intake division and caused some of the cases there to sit longer. This is the overall duration of cases at each phase with the targets on the right. Again, you can see some upticks in the timing targets in the last quarter, Q3. Previous to that, they were generally on a downward trend in intake and in investigation. We have seen a general downward trend. If you look in the middle graph, we've seen a general downward trend in both the average and median closure and investigation over roughly the last year and a half, which is good. The number of cases in charging, it stayed roughly the same with some fluctuations. The number of cases in charging is a smaller number, but even with that smaller number, looking at that overall trend should be meaningful. These are our quality reports. As you can see, the number of cases that we've had returned from the complaint review unit for reasons other than new evidence remains very low. The percent of Walker petitions denied, which we hope to keep at 100%, has remained there. I will advise the board, the council, the board, that we do have one Walker petition that was granted that will show up in the next quarterly report, and we'll look at why that was. On the top right is the random audit reopens. As you can see, there is a line there going up above our target line. We'll be reporting on the random audit later. That is something that we're going to be working on trying to bring down the percentage of cases recommended for reopening by our random audit. These are the overall performance indicators for Q3. You see a lot of red there. At the top left, our inventory has increased. Our caseload clearance rate has decreased. On the bottom left, the average days in investigation, we saw an improvement for non-complex cases, but essentially the steady for complex cases. The average days to close increased for non-complex cases with a slight increase for complex. All of these, I believe, are driven by the increase in incoming cases that affect all of these in the ways that would show there. The other figures we've already discussed. Two measures that aren't in the ADR in this form. This is a report on our diversion cases. As you can see, we've had 1,289 cases that have gone to diversion, and of that, roughly 766 have successfully completed all the conditions of diversion, which is a 97% success rate. This again is a preventive measure, so we're hoping that this will actually have some impact down the road in ideally decreasing the number of complaints as attorneys learn to address some of the issues that cause complaints to arise. This is a report on the Public Trust Liaisons Attorney-Client Bridge Program, which addresses two types of complaints before people file complaints. Requests for returns of file and complaints that attorneys are not communicating with them. This provides an alternative to the discipline system to resolve those. You can see in the graph that the number of cases being handled by this bridge program appears to have kind of leveled off. The red line shows the number of complaints that OCTC is getting on these issues. It does appear, based on this data set, that the PTL's attorney-client bridge program handling these cases potentially is removing some cases that otherwise would be disciplinary complaints, which is the goal. This is the report on disciplinary filings. There has been a slight uptick in disciplinary filings since its low back in 2023 or 2024. This too is the focus of our goal for the upcoming years. We do think we should be filing more disciplinary charges. And so we are going to be focusing on trying to identify cases that should be filed and getting those filed over the next couple of years to try and bring these numbers up. We also included, for informational purposes, some reports on some cases that were filed and/or resolved by stipulation or by decision by the court in the third quarter. We do this so that you can get a sense of the types of cases we're handling as an adjunct to the numbers, so that you can see what's behind the numbers, and in particular what's behind the charging numbers. Many of these cases take significant time to work up, as evidenced by the nature of the charges that are described here. So we wanted to provide that to you to give you that sense of our workload as well, kind of a qualitative look in addition to the numbers. We do track respondents with multiple complaints. Generally, we have been seeing that the number of attorneys with 40 or more complaints is typically around 1%. The number of attorneys with 15 or more complaints tends to vary between 4 and 6%. We look at this each quarter to see if there's any aberration from that normal number. There wasn't. This is consistent with what we're seeing. And with that, I'll turn it over, and if there are any questions, I am happy to try and answer them.
Any questions for George on metrics? Yes, San Francisco.
Mr. Cardona, you mentioned that OCTC thinks that it should be filing more disciplinary cases against attorneys. Could you expand upon that a little bit more? Give us a sense of your reasoning for that.
And then
I also have a comment. Yeah.
We have a particular backlog of cases that have moved from investigation into our pre-filing phase. That is, we have a backlog of cases that have been identified after investigation as warranting charges that have basically been sitting for longer than they should in that stage. And so one of our goals over the next 2 years is to try and bring that backlog down, which should have two impacts. One, likely result in more charges as we resolve that backlog, and two, decrease the overall age of our inventory, because those cases tend to contribute in an outsized way to the inventory, the aged inventory.
Okay, and obviously, you know, it's in the public's interest to have those disciplinary cases brought sooner rather than later, right?
Yes.
Okay, and then I also had a comment, again, not to beat a dead horse, but you know, you and your team at OCTC have been doing more with less. You've had some innovative programs that have reduced some cases. And yet, you know, the 17% uptick in complaints, we haven't seen a similar 17% uptick in each of the areas. So there's obviously a lot of efficiency and innovation going on. But if there's yet another uptick in 17%, this is just a completely impossible situation. So again, I would just underscore, for my fellow trustees and anyone else who's listening out there, that we need to get OCTC more resources and more attorneys, not just to deal with this uptick, but also any uptick in the future. I know we don't know what's caused it, but it could be that there's more reporting, by clients of bad behavior by their attorney or behavior that they think is bad and should be investigated, which is a good thing. But we want to make sure that we investigate those promptly and deal with it promptly, because that's obviously in the public's interest. So again, just another plea for more resources for OCTC. And also, kudos again, George, to you and your team for doing more with less and doing a really good job in light of, frankly, a very impossible situation. So thank you.
Thank you. Any other comments or questions?
I also had a question about the comment that George made about disciplinary charges. George, that doesn't presuppose the type of disciplinary charge. It's just that there needs to be, that backlog needs to be dealt with.
Yes. The charges range the gamut.
Okay.
We have a wide range of charges. It's not any one particular charge that is sitting there.
All right. Trustee Harrison.
Yes, I just wanted to make the comment that I appreciate all your hard work, George, and the work of your team. Thank you for making these processes more efficient. And I want to share Trustee Good's concern about the resources and staff. And I also want to encourage the state bar and by extension, the legislature to take a bigger interest in this so we can get you the staff you need to reduce that caseload and speed up the processing time. Thank you.
Anyone else? And no fears, anyone. The Cardona Show continues with our next item. So whatever you forget now, you can always try and remember then. If that's it, George, should we go on to 5.3?
Sure. And I think I have a short PowerPoint on this too. This is our report on our twice yearly random audit. Great. So basically, as a refresher, every 6 months, we have a set of random auditors take a random sample of closed cases and review those cases to ascertain whether we have been treating those consistent with our procedures and policies, consistent with statutory provisions and case law, consistent with the appropriate exercise of prosecutorial discretion, and identify any things that they think we need to work on based on their review of those cases. The current audit is hopefully the last of our catch-up audits. We're now up to February 28th of 2024. So we are getting close to the point where we'll be reviewing closer to the time that the cases are closed. The catch-up was a result of COVID and an effort to catch up for things that weren't done. Basically, the random sample is selected from cases at each stage: intake, investigation, and charging. And in addition, there's a special focus on respondents who have 15 or more complaints so that we get a sense of how we're handling those complainants. That was done in part in response to the Girardi matter, to ensure that we're not missing people who have repeated numbers of complaints. As you can see, and this was reflected in the previous report, the auditors in this instance recommended that we reopen 17 out of 255 of the cases they examined, which was 6.7%. That was an increase and a significant increase above target. So we've been looking at why that is and trying to talk to the auditors to try and sort out what's driving that. Some of the areas that were addressed and that were focused on by the auditors, the rule of limitations. They did note fewer errors in this audit than in prior audits. This has been something they focused on in each of the audits. We did provide training on this in both 2022 and 2023, and in addition, we implemented some new procedures in 2024 to try and ensure that people are looking at this. We have a checkbox that requires people to indicate that they've reviewed the rule of limitations and identified the appropriate areas. We're hoping that that's what's driven the reduction, but this is an area for continued improvement moving forward. Similarly with conflict checks, in this audit, unlike the last audit, there were more errors in conflict checks, which is not good. We had put new procedures in place in 2022. We streamlined those in 2023. We do annual training each year on this. We just did our training on November 6th of this year. We focused on some of the things that were identified in this audit as potentially driving the errors in the conflicts reporting. So we will hope that this brings it down again. We're also looking at our procedures to see if we can streamline those more to make it easier for people to do the conflict checks, but this is something we'll also be looking at as we move forward. Communications with complainants in both closing and assignment letters. This is a repeated area of concern. This generates complaints from complainants about our communications as well. We did provide training on this in 2023. We've modified our sample language to try and make it simpler and easier for complainants to understand. We just rolled out over the last 2 quarters a new software tool for generating closing letters that has more template and standard language that we hope will help with communication. We will see if that works. We've also changed our procedures for case assignment letters with the goal of getting those out more quickly and letting people know that their case has moved forward to investigation, which we hope will also address some of these concerns. This is also something we'll continue to focus on because, as I say, it generates the most complaints to us from complainants about lack of communication. Investigation delays. We've taken a number of steps to try and improve this. Some of this is outlined here. This is, again, a continuing area that we're going to try and focus on. Communications with respondents, making sure in particular that when we send out inquiry letters to respondents, we are accurately summarizing what the allegations are and what information we need. Again, we've rolled out a new software tool to generate these, and we will see if that works. Prior complaint histories, we've implemented a number of mechanisms to try and ensure that everybody reviews those, and those seem to be working. Some areas of training that we've provided in response to a number of the audits. We just did training in August on the current audit results to cover those. In addition, we provided training on the Lawyer Assistance Program, and we provided training on investigating and trying domestic violence cases. Family law and domestic cases are one of the ones in which we get a number of complaints, and so we're hoping that that training will assist in handling those. And with that, if there are questions, I'm happy to answer them.
Questions for George on the random audit of OCTC? I think that takes care of it. Mr. Cardona, thank you very much for your time with us today.
Thank you. I will be back later.
And I think with this, it's now gotten to the time for our lunch break. We will take a 30-minute lunch break, which looks to me like getting us back here 12 minutes after 1 o'clock. Let's shoot for that. And see you all then, and we'll put the video on hold.
And recording.
Great. Welcome back from lunch, everyone. We will now continue with our agenda, item 5.4, update on the recent actions from the Supreme Court on rules relating to regulation and discipline. And we are joined by Stephen Moad and Shelby King. Good afternoon, folks.
Good afternoon. Thank you. See, we have the PowerPoint up. So since at least when I arrived at the bar in 2017, the board has always taken an interest in both the operation and fairness of the discipline system. And it was with fairness in mind that the State Bar commissioned the Farkas Report, the study of disparities in the discipline system. And we also made several changes to the way the Office of Chief Trial Counsel and the discipline system functioned. It was with these two interests of efficiency and fairness in mind that in November of 2020, the board approved a charter for the ad hoc commission on the discipline system and directed staff to solicit applications. In January of 2021, the commission was staffed and the commission was charged with reviewing the changes the State Bar implemented to improve the functioning of the attorney discipline system over the last several years. The commission was also charged with assessing the efficacy of existing reforms and identifying additional measures to enhance fairness and effectiveness, with a particular focus on addressing any disparities that may exist based on race or gender. The ad hoc commission made 9 recommendations. Following public comment on those 9 recommendations, the board directed staff to develop 4 additional recommendations, and staff returned with the original 9 recommendations, the 4 recommendations the board directed staff to develop, and 1 additional recommendation that was related to the commission's work. So today we're going to address 2 of these recommendations. The first is expungement, and the second is monetary sanctions. In regards to expungement, the ad hoc commission recommended the Board of Trustees adopt timelines for expungement of attorney discipline records. The timelines proposed by the ad hoc commission were private reproval was 1 year from when the conditions were met. A public reproval was 3 years. Probation with stayed suspension was 3 years from the conclusion of probation. Probation with actual suspension was 5 years from reinstatement, and disbarment was it would remain public indefinitely or no change to that policy. Monetary sanctions, in regard to monetary sanctions, the ad hoc commission recommended that monetary sanctions be eliminated because other jurisdictions don't impose sanctions in addition to costs, and the costs imposed by the State Bar are higher than other state bars. And high costs can negatively impact rehabilitation. Shelby King from our Office of General Counsel will be talking more about monetary sanctions in just a minute. In November of 2024, the board approved proposed new rule 9.33 of the Rules of Court, which authorized expungement of non-disbarment discipline after 8 years from the effective date. This was different than the recommendation from the ad hoc commission. The proposed rule specified that the 8 years would be calculated from the effective date of a public or private reproval, termination of probation on a probation with a term of stayed suspension where there's no actual suspension imposed, and termination of probation or reinstatement following termination of the actual suspension, whichever is later when there is a term of actual suspension. So that petition was drafted by the Office of General Counsel and forwarded to the Supreme Court, filed with the Supreme Court. The Supreme Court denied proposed Rule of Court 9.33. I do want to note that the Supreme Court retains the authority to expunge a licensee's discipline history, and licensees remain free to petition the court for such relief. I do note that at the time the ad hoc commission was considering this, there, to our knowledge, had only been 2 requests for such relief, and neither were granted. But that avenue remains open. In addition to approving proposed Rule of Court 9.33, the board also directed staff to develop a legislative priority to exempt expunged convictions, expunged discipline from the CPRA. That is tied to if we were going to expunge the discipline, in order to make that meaningful, if you will, we needed to exempt it from the CPRA in order to eliminate the need to turn that over in response to a CPRA request. The board also adopted the website removal policy as to administrative suspensions and directed staff to return a policy on website removal of discipline following the Supreme Court's consideration of 9.33. So the remaining issues include removing of a criminal conviction transmittal where the sole underlying basis for the discipline was a criminal conviction for which relief was granted under Penal Code Section 1203.4 and some other similar sections, and removal of the notation that a licensee resigned with charges pending. And I would note that the removal of discipline was covered in the expungement rule. In the discipline of former licensees was also planned to be removed at the same timeline as any other licensee. So at this point, I just want to let you know that staff does plan to return to the board in the future, in the new year, with a request to eliminate the legislative priority to exempt expunged discipline from the CPRA for now, at least until we have some sort of expungement of discipline, if any, and also to determine how the board wants to proceed with website removal of discipline, criminal conviction transmittals, and the removal of the notation that a licensee resigned with charges pending. So that's my portion of the presentation. I'll turn it over to Sheldon.
So the second rule that we're here to discuss regarded monetary sanctions. Again, the proposed amendments would have reduced the guidelines for monetary sanctions. So the recommended amount of sanctions in the case of suspension and resignation with charges pending were reduced to $0, and the recommended amount in the case of disbarment was reduced to up to $1,000. Additionally, the amendments clarified that installment payments for monetary sanctions could be added to the licensing fees to assist with enforcement. So the Supreme Court chose not to reduce the guidelines for monetary sanctions. Instead, they created a minimum baseline amount. So for example, here in the case of disbarment, the current language is up to $1,000, and the Supreme Court's order indicates that the monetary sanctions baseline is $1,000. The State Bar Court may, in its discretion, recommend monetary sanctions in an amount less than or greater than the baseline amounts set forth in the right-hand column, subject to the $50,000 statutory maximum per order. However, a deviation must be based on the facts and circumstances of the case, and State Bar Court must state its reasoning for deviation. In addition, in the amendments, there was also an emphasis that State Bar Court is only recommending monetary sanctions for the Supreme Court's final order. And the court did not give any reasoning for their rejection of our proposal or for the new language. And the effective date for the amended rule is January 1st, 2026. And a note on next steps, State Bar Court will update the published rules of procedure, and then State Bar Court, Chief Trial Counsel, and Regulation will consider and implement any necessary operational changes to comply with the rule.
All right, thank you very much. Any questions or comments? Trustee Buenaventura.
Yes, thank you, Mr. Chair. Stephen, can you tell us if in the rejection of the Supreme Court for on the issue of expungements, did they give any sort of guideline or reasoning for the rejection? Was it the 8-year benchmark? Was it just expungements in general? And then what is the procedure for perhaps revisiting this again? As you know, I was on the ad hoc commission that made some of these recommendations, and a lot of us on the commission we worked hard at coming up with some guidelines and the issue of expungement, knowing that it was quite an arduous process and that only 2 expungements have ever been granted. And so, although, again, I will say I respect and we should respect the Supreme Court's decision, but I'm I'm just curious if does that mean the issue is final, or is it something that this committee, this board can raise again? And when you said that you're going to be bringing up some recommendations in the future, is the recommendation going to be to not proceed any further, or can we do something else about it?
Great questions. So I do not believe that the Supreme Court order itself gave any indication as to why. I believe it was just that the proposed rule was rejected. I don't know whether that means that was a particular objection, whether it was the 8 years or the concept in general, or they would be amenable to something else, at least from the face of the order. As to whether we could submit something again, I assume the answer is yes, but I think that's probably a better question for General Counsel than me, but I assume the answer is yes, and we could just see what the Supreme Court does with the next proposal. As far as your question about what staff intended to return, at this point, the plan would be to return items that are responsive to the current state, which is that the petition had been denied. Now, if the board directs us to return with a different expungement proposal, we can certainly do that.
Thank you. Any other trustees? Trustee Harrison.
Yes, I just had one question, a question I think I already know the answer to, but for an attorney to file a petition for expungement, they file it directly with the Supreme Court. They don't have to go through the state bar first?
I believe so, yes. It's the Supreme Court that would hear that petition or rule on that petition, so I don't believe the state bar has any involvement with that. Although I can tell you that I'm not aware of a specific rule that addresses this.
All right, thank you.
Yes, Trustee Sowell.
Just trying to understand whether or not there's any linkages here. Earlier today on the consent calendar, we dealt with expungement related to MCLE, noncompliance, as well as licensee sort of payment, the non-payment. Is that also a part of this rubric in some fashion?
It's not, although that was a consideration for part of at least some people on the ad hoc commission, because there are rules that authorize that expungement of those administrative actions after a certain amount of time. So those two consent calendar items are annual things that are already based in rules of court. So those are already existing expungement of administrative actions.
Yes, San Francisco.
So Trustee Buenaventura, I wanted to address your point. As you know, I thought expungement was very key in redressing some of the racial disparities. So I'm of course disappointed in the outcome. But in my mind, the Supreme Court has spoken. They're not interested in it, and I don't think we should pursue making another proposal. I think we have a lot of things to do and limited resources, and we should focus on those things. From my perspective, I think it's final and it's done. So I just wanted to sort of share that with you. Thanks.
Thank you. Anyone else? Yes, Trustee Tony.
I welcome this decision by the Supreme Court. I welcome this decision by the Supreme Court and think it's the right one. This is a motion that I voted against. Yes, the State Bar did approve it, but I did vote no on this. And, the question here is, I do not see how this protects the public. Okay, that's why I voted no on it. I think there are a few lessons from this, from my point of view. I'm not speaking for anyone but myself. One, an ad hoc commission, if there's ever one set up again, should not be 23 attorneys and 3 non-attorneys. That in and of itself creates a tremendous structural bias on the side of wanting naturally to protect the profession. That's one. It should be more balanced. I think the second issue is that I hear from the Supreme Court a message that we should not be going easy on attorney discipline. Okay, these two proposals, both the expungement and reducing the monetary sanctions, are going easy on attorneys. That's my interpretation. Other people may see different things. And third, the Supreme Court has also sent a message, I think, that they do not want the state bar to restrict its ability and jurisdiction over expungements, which they, have had, and the message is that they continue to want to exercise their authority. Those are my comments.
All right, anyone else? All right. Oh, sorry, San Francisco.
Yeah, I just wanted to say I completely disagree with everything that Trustee Tony just said, just so the record is super clear. There were consultants that recommended this. There were a lot of other things that recommended it. That said, I don't think we need to rediscuss it because the Supreme Court has spoken and doesn't want it. But I just wanted that to be registered on the record. Thank you.
Thank you. Anyone else? All right. Let's go ahead.
So I think Steve teed this up to some extent, that this still does require some sort of board reconsideration of that website removal policy as was teed up back in November. So what I think Steve and the rest of us are seeing this as is kind of a temperature check for you all. And staff will ultimately bring back a final recommendation to address this and some of the ancillary issues associated with this at the February meeting. So just to kind of leave that one where it is.
All right, very good. Thank you, Steve. Thank you, Kirby. I'm sorry, sorry, Shelby. Let's now go on to item 6.1, an update from the Office of Admissions. Ms. Hershkowitz. Thank you.
Good afternoon. Donna Hershkowitz, Chief of Admissions. CIC Tara Clark has been promoted. Just waiting for Cody Hunanian also to be promoted. And then, excuse me. And Tara, there we go. And Tara's going to be sharing her screen. Between Tara Clark and Cody Hunanian, who are program directors in the Office of Admissions, and myself, today we're going to give you some updates on the following 5 topics. The results of the July 2025 bar exam, which were recently released, the recently administered legal specialization exams and the first-year law student exam, the upcoming February 2026 bar exam, and some sort of following on the presentation you just heard, recent Supreme Court actions on admissions-related rules. Tara, next slide, please. The results for the 2025 bar exam were released on November 7th, so just a couple of weeks ago. That is 14 weeks after the conclusion of the exam. For our February exams, results are released 9 weeks after the conclusion of the exam. And this is a reduction of the time that we take to grade the exam. Several years ago, we reduced each of those by 2 weeks. So it had been 16 weeks for the July exam and 11 weeks for the February exam. It's now 14 and 9. But this year, staff really created internally some real transparency on all of the steps that are taken in the process for us to get those results posted. And by looking at that process, we are now exploring changes that can be made to reduce the timeline, specifically for the July exam. I'm hoping that by the July 26th exam, so the next July exam, we might be able to shorten that timeline by another week. We saw some room for improvement in that, and so that's going to be a goal for us, is to try and reduce that timeline further. Obviously, that's something that's incredibly important for the test takers, and so that's something that we are going to strive to do. But I want to talk to you a little bit about, very briefly, about the results from the July 2025 exam. Tara, slide please. So overall, there were 7,740 test takers for the California bar exam. The California bar exam is made up of two components. There's the general bar exam, which is the 2-day exam that the vast majority of people take. And you see on this slide that 7,362 people took that 2-day general bar exam. And then there's the attorney exam, which 378 people take. You can be an attorney and take the general exam. There are requirements to qualify to take the attorney's exam. And some people choose, regardless, to take the 2-day exam. But there were 7,362 takers of the general bar exam. 74% were first-time takers and 26% were repeaters. This is a slight change in that normal breakdown from year to year. If we look back at the July 24 exam, it was 68% were first-time takers and 32% were repeat takers. And that's typically what we see. February exams tend to be 2/3 repeat takers and 1/3 first-time takers, and July exams tend to be the opposite, 2/3 first-time takers and 1/3 repeat takers. The pass rate for the general bar exam went up 1 percentage point from the July 2024 exam. Because the cohorts are so different between February and July, we always compare July to July or February to February. So you see the pass rate was 54.8%, so that is an improvement for us. And on the attorney exam, there were 378 exam takers, which is a slight increase from the number of exam takers in the prior July. The pass rate, however, was lower for the attorneys than in the past at 43.4%. I did want to point out the breakdown of the pass rate between first-time takers and repeat takers, specifically because the pass rate for repeat takers at 12.4% was about half of what it was the same time for the July exam in 2024. And so we think that in talking with the psychometrician and just looking at our own statistics, that's attributable to the fact that there was such a significantly higher pass rate overall for this past February exam. For both first-time takers and repeat takers, so people who would have could in another year might have failed the February 2025 exam would be taking July 2025 and might have passed at that time. You'll see in the footnote there that on average the number of the repeat takers had an average this time of 5.1 times that they've taken the exam. Which is slightly higher than the previous July exam when it was 4.8 times for repeaters. So that also sort of these are folks who have repeated more often, and the statistics tell us that that as you proceed beyond three times taking the exam, the more times you take it, the less likely your percentage chances of passing the exam. Next slide. So the next three slides do a little bit of breakdown of the pass rates of the two-day bar exam, looking at law school type, race and ethnicity, and gender. These charts are preliminary. Once we release results, we work with the law schools to make sure that all of the applicants that we have allocated to their school, that allocation is correct. So there could be minor changes in these numbers, but we wanted to just share the numbers here, the breakdown of the first-time and repeaters by school type, and just share that information with you here. I don't think there's anything that is sort of particularly surprising, maybe, except for the pass rate for the first-time pass rate for graduates of unaccredited law schools exceeded the first-time pass rate for those of the California accredited law schools. So that's something for us to keep an eye on. Next slide. You will also see the pass rates by race and ethnicity, and I apologize I didn't bring the comparatives for last July. We do post those on our website, and so we do have comparative information for year over year, and we can take a look at that. You'll see that there is a fair amount of disparity when looking at the pass rates by ethnicity, whereas on the next slide you'll see that there's a fair amount of consistency in looking at the pass rates by gender identity. So that's sort of differences for race and ethnicity and law school type, but fair amount of consistency for gender identity. Next slide. Cody?
Great. Thank you so much, Donna. If we could just go to the next slide, I want to start just with some quick background, particularly for some of our newer members of the board. Because of the fact that the legal specialist examination occurs once every 2 years, the background, general kind of design of the exam might be new information for some of our members. So I wanted to first start just by describing the exam that was just administered. We have a multi-year exam development effort that leads to us producing 13 different exams in 11 different specialty areas, with each of the exams containing 8 essays and 75 multiple choice questions. The October 2025 legal specialist exam was the first to be administered with a combination of live remote proctoring and test centers at small vendor-owned test centers. To be clear, this is not the first online version of legal specialist examination. We've used other online approaches, but the first to have a live human remote proctoring. We've seen over several years a trend of declining applications to take the legal specialist examination. So this year, we took advantage of the state bar's all licensee email, as well as some generous bar affinity groups and local bar associations that were willing to help us get outreach out to current attorneys who are interested in legal specialization. Let's turn to the next examination just to give you some top line numbers about this administration. We ultimately had about 398 applicants sit for the exam out of 415 who were approved to do so. As I mentioned, there was a remote component. So we saw that 79% of test takers sat for the exam using that online remote option. Of the 398 applicants, we had 18 applicants that had reported technical issues that required some staff support. So these are folks who either contacted us through our applicant portal or via telephone and needed some additional support, either re-entering the exam or rescheduling their component. or rescheduling a new appointment to take their exam. Ultimately, 17 out of those 18 were able to complete the exam. One individual decided to withdraw from the exam. Results will be released in March 13, 2026. From there, there's some additional requirements of individuals interested in becoming a certified legal specialist that they'll need to complete, I believe, within an 18-month timeline. In my last slide, I want to share with the members just some interesting statistics about the interest in specific specialty area exams. For many years, we have seen family law, estate trust and probate, and the workers' compensation exams really be the most popular and common for applications. And we've seen a general trend in some less common exams, particularly admiralty and maritime law. We haven't had an application for that exam in at least 2 exam cycles. So we are sharing this data both here with the board, but this is certainly some trends that I believe the California Board of Legal Specialization will be interested in discussing at one of their upcoming meetings as well.
Thank you, Cody. And good afternoon. So I'm going to briefly go over our last administration of the first year law students exam. And as a reminder, so not all applicants take the exam. Generally, it's those who attend one of our registered law schools, registered unaccredited. They study through the Law Office Study Program, or they have not completed 2 years of college work and they're attending either an ABA or a Cal accredited school. And as of June 2024, the first year now consists of only 100 multiple choice questions, and it's administered in 2 sessions. And just like with the legal specialist exam, we did administer it with the Prometric services, both live remote proctoring and at small test centers. So for this October exam, we had 195 applicants take the exam. 26 of those tested remotely, 74% in person. We only had about 2% of those who had issues requiring staff support, anywhere from having to reschedule or not being able to get into the session initially. And then our results will be released in a little less than a month. And as Donna mentioned, with the bar exam, we're also looking to see if we can shorten this results window for the first year exam, since we are now doing multiple choice only. Okay, and moving to February 2026. So this is our next bar exam coming up. So here we have our numbers as of November 7th. This is before the results were released, so actually I have updated numbers for you. So as of this morning, we have 4,008 applications. 591 of those used a waiver. 38% of those with the waiver are attorney applicants. And the application closes on January 2nd. So we still have a little ways to go for the folks to apply. We have secured all of our exam sites now. I think at prior meetings, you were aware that we were still looking for something near the Sacramento area as well as San Diego area for testing accommodations. So at this point, we have secured all of those locations. They are in our system for applicants to choose for the laptop and writer, and then testing accommodations as they are approved. Applicants will be assigned to those test sites. And back to Donna.
So we wanted to provide you with an update on 2 admissions related rules packages that were acted on by the Supreme Court since the board's last meeting. Slide, please. First, the testing accommodation rules. After extensive work by the Committee of Bar Examiners, which included 2 stakeholder forums to get input on the testing accommodation rules, and 3 separate rounds of public comment, the Committee of Bar Examiners recommended approval of the testing accommodation rules to the board. The board recommended approval of those rules to the Supreme Court. Those rules were transmitted to the Supreme Court in June of 2024. And we have been awaiting their response since then. There were a lot of procedures that were put into the rule packages that hadn't been specified in rule before. some of the sort of the day-to-day operations of what we would consider. And so staff were, with the advice of the Office of General Counsel, actually implemented a lot of those changes because they weren't required to be done in the rules. And so there were a lot of changes that improved the processing for applicants, that made it easier for them to get testing accommodations, that reduced the paperwork that needed to be filed. Anything that was sort of on the applicant-friendly side were implemented. Things that had been in the rule previously that we were seeking to change, obviously we could not act on those until we heard from the Supreme Court. So nearly a year and a half after the submission, the Supreme Court dismissed the request, our request for them to adopt these rules. They didn't deny it; they dismissed it, and the reason is that since we'd submitted the rules, as you all know, there was a recent changes to the rules in Title IX of the California Rules of Court, and in particular, there was a rule that had previously said that all rules that are approved by the Committee of Bar Examiners must be submitted to the Supreme Court for review and approval. The rule was changed by the court in this latest rule package to specify that rules affecting the prerequisites to be certified for admission to practice law must be submitted to the Supreme Court for its review and approval. So those are things like moral character determination, right? That is a prerequisite to be admitted to the practice of law. So rules on moral character would need to be submitted to the court. Rules on the bar on the bar exam, but testing accommodations are seen as sort of a way to take the bar exam, a way to meet the prerequisite, and so the court determined that. That CBE having approved the rules, the Board of Trustees having approved the rules, and in light of the new language in Rule 9.5A, that the Supreme Court was not required to approve the rules, and so the rules will be effective based on the prior approval by the CBE and the Board of Trustees. And we're making them effective 60 days from the date of the court order dismissing them, because that was the time frame that we had asked the Supreme Court, if they adopted it, to make the rules effective 60 days so that we would have time for some programming on the remaining rules that needed to be implemented. The second admissions-related rule package that was transmitted to the Supreme Court is the rule package that changed our registered military spouse attorney program to the registered service member and service member spouse attorney program. These rules were transmitted to the Supreme Court on August 5th, so a very short time ago, following the approval of them in June by the Committee of Bar Examiners and on July 3rd by the Board of Trustees. The impetus for the change in these rules were changes to the Federal Service Members Civil Relief Act that essentially required our registered military spouse program to now extend to service members themselves and not just the spouses of service members. And the federal amendments also required the relaxation of certain requirements. So we worked very closely. Actually, our Office of General Counsel led the effort to make those rule amendments, and the court adopted those amendments with some modifications just a month and a half after they were submitted. The key modifications, if you look at the red line, it frankly looks like there are significantly more modifications than there were. But the key modifications that the court made were one, shortening the amount of time that a service member spouse could remain in the program after the dissolution of the relationship with the service member. Importantly, the existing registered military spouse program had contained the exact same timeline that the service member's spouse had 1 year after the dissolution before they were terminated from the program. The court, in looking at the whole package now, decided to reduce that from 1 year to 90 days. The second key change, and this aligns, Trustee Tony, with what you were just saying about the expungement and the monetary sanction rule package, that the court, in your mind, was sending a message that we wanted to sort of be, I think you said be harder on attorneys, that we wanted to really sort of make sure that we are thinking carefully about the discipline of attorneys. This other change really, I think, aligns with what you just said. Under all of our other existing multi-jurisdictional practice rules, our registered in-house counsel rules, registered legal aid attorney rules, and the prior registered military spouse attorney rules, the eligibility requirements were that you could not have been disbarred or a suspended attorney, and you could not have been resigned with charges pending. The Supreme Court, in wanting to sort of be more cognizant of the level of discipline, type of discipline somebody had, said no, in order to be eligible for this program, now you must not have had any discipline imposed, so not just disbarred or suspended, and added a requirement that you not be subject to disciplinary investigation currently. So we didn't see this coming because the language that we had was consistent with the registered military spouse attorney rule and the other multi-jurisdictional practice rules. Obviously, as we move changes to the other multi-jurisdictional practice rules forward, which we're hoping to do in 2026, we will be updating those eligibility requirements to match the message that the court has sent us with these rules. And then the other change was just making clear that we will be conducting a background check to verify eligibility for anybody who applies for the program. That certainly was the intention, and the court wanted to make sure that it was just crystal clear to the people who'd be applying for the program that there would be that background check to verify eligibility. And with that, Cody, Tara, and I are happy to take any questions about the update.
Any questions, Trustee Harrison?
Yes, what jumped out me was when you were updating the percentages for first-time test takers, Black students at 29.7% versus white students at 68.7%. That's a huge disparity to me, and I was curious to know if we had any data to link it to the pass rates for ABA accredited schools versus non-accredited schools by the ABA. Like, for example, are the majority of Black test takers going to unaccredited schools by the ABA or not? Do we have that information?
We do have it, and we can run those crosstabs and provide that information. I don't have it with me today, but that's certainly information that we can provide and update you. I think you will see that there is that relationship, that there are more Black and African American test takers who are going to the California accredited schools and the registered law schools percentage-wise than the ABA-approved law schools. So I think you will see that correlation, but I can bring that to you the next time.
Thanks. And I was curious if there was any effort, maybe by COAP or the state bar proper, to address that issue, or maybe I've heard from the law schools that they're taking a concerted effort to address that issue, the accredited law schools by the ABA.
So there are a couple of things that we've done in the past. We looked at several years ago. We did a differential impact analysis to determine whether there was a disparate performance on the essay questions, the performance test questions, or the multiple choice questions by race or ethnicity, by gender. The overall determination at the time was that there in certain instances there was some differential performance, but it was not significant. And I can that was a study that we did in 2020. But one of the things that we did do at the time was we developed some differential, what we call them, the differential item functioning guidelines. Guidelines for question drafting to try and eliminate as much differential performance as possible by making sure that people were thinking about things when they were thinking about certain things when they were drafting questions, and when the Committee of Bar Examiners is reviewing those questions. Those guidelines are given every year to those who are reviewing the questions. Those guidelines were handed out to the content validation panels when we were reviewing the multiple choice questions, and we'll be reviewing essay and performance test questions. That's part of our normal practice to do that. So that is certainly something that we've been doing. We've also in the past, in our meetings with law schools, talked about their programs to prevent attrition and to support students from underserved populations. So those are efforts that we have engaged in the past to look at that issue, because yes, that is obviously a very stark difference that certainly has drawn our attention as well.
Yeah, and I just wanted to make a comment. So I did a piece on imposter syndrome. It's on the State Bar website. And when it comes to applying for ABA accredited law schools, I experienced myself, and I surmise that other Black or African American people who aspire to become attorneys experience this too, where they may make the decision not to apply to certain ABA accredited law schools in California because they think they can't get in, and they aren't aware of a pathway to get in if they, for example, might have a less than stellar LSAT score, but maybe they have a good GPA, good references, good experience, but that LSAT score where it's at. Schools like the law school I went to, UC Law San Francisco, formerly UC Hastings, have the Legal Education Opportunity Program, where you can apply through that program and get admitted by showing leadership qualities in the sense of having overcome significant adversity in one's past. 20% of the students at UC Law San Francisco get admitted through the Legal Education Opportunity Program. And that law school has thousands of law students. It's, I think, maybe around 1,500. When I went there, it was about 2,000. Other law schools obviously have a lower level of enrollees, but maybe if there was some type of publication about the various programs at the law schools here in California that are ABA accredited and what type of pathways to entry exists, like, for example, the Legal Education Opportunity Program at UC Law San Francisco, it could be a resource for students who might be experiencing that imposter syndrome and make the decision not to even apply for a law school that's ranked high because they feel like they just don't have a chance to get in. That's my comment. Thank you.
So I would note, thank you, that jarred a couple of things for me. And I think what I hear you saying is some way to make students aware of those programs. One of the things that we did a few years ago at one of our gatherings of all the law schools was we had representatives from your law school present on the LEAP program. There were a couple of law schools that presented because they had unique programs that supported students from diverse backgrounds and had, as a result, had lower attrition rates. And so it was something that we were advertising to other law schools with COAF, working on also developing sort of best practices. So that's something that we had been looking at. The other thing that we've been doing for a number of years with each bar exam is something that the name has changed over the years, but I think we're still calling the Bar Exam Strategies and Stories program, otherwise referred to as Milestones in Legal Education, sometimes referred to as Protective Mindset. But it's a program that we partner with some researchers on to provide an opportunity for law students. They can, for free, sign up for this program, and there's a very small commitment of time on their part to participate. It is intended to deal with things like imposter syndrome, to really give people confidence, more confidence as they are studying for the exam and sitting for the exam, the results that we have gotten to date show that there is an improvement in pass rates for people who complete the program, and the improvement is higher for people from underserved backgrounds. And so that is something that originally had been done by researchers at no cost to us, but because of the results, it's something that we have budgeted for and been continuing to pay for to ensure that we continue to do this. We've added something called the Peak Performance Program, and maybe Tara, you can talk a little bit more about Peak, but it is also intended to help improve people's performance and prepare for the exam. And then also through our lawyer assistance program, we have a group for those with for repeat takers to help give them sort of more confidence as they are sitting to take the exam again. So those are some other efforts that we've been doing. Tara, is there more that you can say on anything more you can say on Peak?
Just that it's implemented by one of a different researcher from Stanford, and it's meant to help the students as they're preparing for the exam manage stress, sustain their energy as well as focus. And it's meant to complement the other programs that we offer, including the bar exam strategies and stories.
Thank you.
San Francisco's trustees?
I have a question. Can I?
Go ahead.
Oh, okay. Thank you. Just to sort of add to Trustee Harrison's point, I think the racial disparities in the passage rate, unfortunately, has existed for some period of time. And what we saw with the February bar exam, the disaster that it was, one thing that was less disastrous was that the racial disparity gap narrowed. But now it's back to what it's always been before. But I was going to suggest to the chair that this might be a fruitful discussion at a future board meeting where Elizabeth Hom and Donna can present on a lot of these great programs that the bar has implemented. There's also the California Law Pathways that tries to encourage folks, from community college to consider law school path post four-year college. Lots of really great work that's being done in this area. But I do think that, as my recollection is, while the source of the law school that the person goes to may tell part of the story, there's still a racial disparity nonetheless, and so that should be concerning and should be, subject of our continued focus. So I was just going to suggest to Chair Cisneros that he consider at some point over the next 6 months having somebody come and do a little bit of a deeper dive on this issue that Trustee Harrison has appropriately raised. And then secondly, Donna, I don't know if it's you or Cody, I was very interested in the fact that the remote administration of the legal specialization exam and the first year exam went well, given what we saw with the February bar exam, and also given that the Blue Ribbon Commission on the bar, on which Trustee Harrison sat, made it a key component of what they recommended to do was to have remote testing to increase inclusivity and accessibility of the profession to everybody, as well as reduce costs for the bar. But really the impetus was inclusivity and accessibility. And so I'm interested, even though those are much smaller exam administrations, presumably with different folks than did our February remote bar exam, if there are any lessons learned from that might assist us in further considering, remote testing for the larger bar, in the future. Thanks.
Yeah, obviously that's something that we have looked at and will continue to look at. The exams are very different. The first year law students exam, and that was just about 25% were remote. On that one is just a multiple choice exam only, and it is it's two 90-minute sessions, and that's it. As compared to a bar exam, which is 2 days, 12 hours, 12 hours of testing. That also includes written responses, the performance test, having to have the file and library that you're looking at. The legal specialization exam is an all-day exam, but 1 day, not 2 days. Does have the mix of multiple choice questions and essay questions. And one of the things that I would note, sort of, Cody had pointed out that there was about 5% of the test takers, there were technological issues. It's a very small number, obviously, of a small number of test takers, and yet for that small number of test takers, they would certainly say that it didn't go smoothly. Staff spent, I would say, all day for that small number of test takers, working very hard to get those test takers back into the exam, to get them scheduled for another exam, to address the concerns. And so it was, on paper, it looks like it was particularly smooth. There were certainly some challenges in the implementation of it. One of the things that we are doing going forward for both the bar exam and the first-year law students exam, we will be issuing formal RFPs for the vendors to administer those exams. And we'll be looking at, what do you have the ability to do in person? What do you have the ability to do remote? And we may be in a position where we have the ability to use the first-year law students exam, the legal specializations exam with smaller populations to test out different platforms than we're using for the bar exam, so we can see how 2 or 3 different platforms work. And that's one of the things that we are going to be looking at.
Thank you. Yes, Trustee Solel. Okay, Trustee Harrison.
Yes, I just had a question about the applicants or the test takers who took the remote exam and had software issues or glitches. I'm curious to learn what number of those people, what percentage of those people had those issues because maybe they didn't follow an instruction, for example, to update the software on your computer. In my mind, I categorize that as user error versus an issue with the platform itself. Do you have that information?
Cody, can you speak to that?
Yeah, I'm not sure I can give you a number of those individuals. I think diagnosing a specific computer device problem is challenging. One thing I'll say to that, though, that I think was related to the previous question, it takes a lot of work from staff side to communicate to different test taker populations what they need to know to be successful on a remote exam. And so we learned a lot over the years with the first year law students exam about how to ensure that, a first year law student who's maybe a non-traditional student, who maybe has a full-time job, needs to know and do and how early they need to be communicated to take the necessary steps like the practice exam and all of that. And we kind of had to rethink that communication strategy for the attorneys who sit for the legal specialist examination, who are a completely different audience. And how do we ensure that they kind of take these steps seriously and take the necessary steps? And so that is a challenge. I'll also point out there was, among those 17, I think, a variety of issues. Some individuals maybe couldn't access the exam because of a computer device problem. There was some number of individuals in which there was a kind of a back-end technical issue that kind of prevented their break from ending, and that was kind of resolved in real time. And so the technical issues, I think, do vary. Diagnosing those that are kind of specific to a computer device problem is a challenge. And I'll just say one last thing, though. We do typically have pretty strict rules as far as an individual's requirement that they take the practice exam prior to exam day to try to address potential technical issues. And so for this legal specialization exam, there was a very small number, but a number of individuals who, after multiple reminders didn't take the practice exam, and we withdrew them from the exam so that they didn't face unexpected computer device problems.
All right, thanks.
Trustee Solo.
I think I have a question for both Donna and for Cody. Donna, my question is that you provided some information on the July passage rate year over year. I think I'm interested in maybe a little bit more of a longitudinal perspective on that in terms of what the passage rate has been, and maybe how that compares to maybe the overall average passage rate.
We have a historical document going back to 1951 or something like that, that we can circulate to show you what those pass rates look like. And then we have in the past, and we can update them, but we've in the past done 10-year averages, just to sort of give you a sense of sort of the recent trends and what that's looking like. So we can send those out.
Thank you for that. And Cody, I don't think this is the time nor the place to sort of talk about the need for more immigration attorneys here in the state, given what is happening to residents across California. In terms of being swept up in these ICE raids and then not being afforded their constitutional rights. But I am interested in. I know folks have to self-select to say that they want to take that legal specialization. But how does the 20 folks it looks like that took that exam? How does that compare to previous years?
I don't think that I'm familiar with kind of a longer term analysis, and we could certainly do that. Certainly in the last few administration cycles, the trends that we showed today generally stand, meaning those that have been popular specialty areas continue to be so, and those that are less common have been that way for at least some administration cycles. I think you are tapping into something interesting. The California Board of Legal Specialization's new term will begin in December. And one of the things that staff will be bringing to their attention are findings from the State Bar's 2024 Justice Gap Study, which identified needs related to immigration law as an area where there's a major justice gap. And so we are going to use the information that the State Bar gathers on these issues to focus their attention on some opportunities to either increase outreach to certain areas or identify new specialty areas. So I think you'll see maybe in the meetings in the coming year, some discussions that kind of touch on what you're talking about.
I think I'll leave it there. I just know that I have had some conversations with folks in other parts of the bar about this, and would like to be a part of some of those continuing conversations as some of that information gets transmitted to the Legal Specialization Commission.
Thank you. Anyone else? All right. Thank you, Donna.
Thank you.
Next, we're on to item 6.2, approval of applicant and other fees for admissions programs. We are welcoming Araceli and Justin.
Donna will be joining us for this presentation as well.
Great.
All right, thank you. I'm Justin Ewart. I'm the finance director here at the State Bar of California. I will be going over the short PowerPoint presentation to go over the admissions fee increase that we are requesting. I will start, and if we could proceed to the next slide. Oh, we have a clicker. I will start with a brief history as to why we got here. The board policy is a full fee review every 3 years. In the years in between that full fee review, we apply a CPI increase on the fees that the board has the authority to increase. For admissions, we moved up the fee review to 2025 from 2026 because of the specific needs that arose from the February bar exam administration. And those are related to the return to the in-person administration and that's impact on the fund balance. The 2025 budget that the board adopted in February projected an ending admissions fund balance of $9.5 million, which had a surplus of $3.2 million based on the continuing remote administration. After the February 2025 exam, the forecast changed significantly. The board approved waivers that reduced revenue and was instructed to return to an in-person administration. The mid-year projection that was presented to the board in September showed that the updated admissions ending fund balance would be $3.4 million, a swing of more than $6 million. A $3.4 million fund balance equates to 10.8% reserve, which is below the 17% policy minimum. This large swing shows the importance of a healthy reserve. The chart shows the fees back to 2017, which was the last fee review prior to the most recent one in 2023 and 2024. The bar exam fees were not raised in 2017 because they were raised the year prior. The increase requested today would be the second increase in 10 years. The last column on that slide shows that in 2024, not all of the fees increases brought the programs to break even. Next slide, please. Oh, sorry. As part of the review, we projected the admissions fund fees from 2026 through 2028. During the review, we showed that only applying the CPI increase would lead to a $3.8 million deficit in the admissions fund. With the current projection being $3.4 million, this would cause insolvency before the end of 2026. During the review, staff developed two options. Option one was to set each individual program within admissions to break even. And option two was to set the fees on a more global basis so the fund itself breaks even. Option two is staff's recommendation. The methodology for our fee analysis was we took the revenue projections and subtracted the projected expenses, and if there was a deficit, we increased fees to cover the deficit. Projected revenue was developed by using counts of applicants over a 4-year period. For expenses, we allocated staff time across the 13 programs we evaluated and did and proportioned indirect costs the same way. This chart shows the bar exam fees. Option one is a break even. Option two is a more globally focused. And then the percentage change between the current fee and option two is shown in the last column. Staff did not propose a more significant increase in attorney applicants in this fee this time around because the prior increased attorney applicants 52%, whereas non-attorney applicants were increased 26%. That's why it's increased $150 for both populations. As noted in the item, the recommended fee increase would move California from 12th place to 6th place for general bar exam fees and from 7th place to 2nd place for attorney bar exam fees. The next slide shows the first-year law students exam fees and the moral character determination fees. As you can see with the first-year law students fees, to break even would be a significant cost. This is because there are a lot of fixed costs with the first-year law student fees, but the population that takes it is small. So there's less people to absorb those fees. The increase for moral character determination fees is around 21%. The next slide shows fees that applies to attorneys. These are the foreign legal consultants fees, the multi-jurisdictional practice fees, and the pro hoc vice fees. I will note that there is a difference in the multi-jurisdictional practice fees for registered in-house counsel versus legal aid attorneys. And the benefit to having legal aid attorneys was why the fee was not recommended to be higher. The next slide talks about further attorneys' fees, the out-of-state attorney arbitration counsel, and the legal specialization fees. Then staff have identified increases based on how the program provides unique opportunities for participants to represent their clients in California courts. The next slide shows the student fees, the practical training of law student fees, and the law office study fees. The law studies fees has a CPI-related increase of 3%. The next slide shows the law school regulation fees. And these fees are in line with recommendations. Option 2 is in line with recommendations that the state auditor provided in the most recent audit that was published. This final slide shows the overall. As I previously mentioned, only doing the CPI increase has a deficit of $3.4 million. If the board were to choose option 1, it would be a surplus of $3.9 million in addition to the $3.4 million fund balance. And then the staff recommended is a small surplus of $97,000. And that's a quick overview of all of the attorney's fees. And now I will open it up to questions.
Any questions? Yes, Trustee Harrison.
So I see that in the bar exam fees slide, there is a item that says testing center change fee. So my question is, did these projections include the assumption that test takers would be taking their tests in person and not remotely?
Yes.
Did staff create any type of projections that would have any implications on a bar exam fee increase if the test was delivered remotely?
Oh, okay. We did not because under the recently enacted statute, we would have to give a 2-year notice in order to switch from an in-person exam to a remote exam. And being that the period of time that's covered by this fee increase is 2026, 2027, and 2028, it really wouldn't lend itself to us transitioning to a remote exam. Additionally, the board has been cautioning us as we've been talking about the future exam about not thinking that we weren't thinking that we would be returning to a remote exam very quickly while we continue to research technology and make sure that it would be something that would be able to be handled competently at such time as we chose to go in that direction.
So we don't know if maybe for the next 2 years or so, we might run out of deficit, but once we switch to a fully remote exam, we could be running at a surplus, right? We don't have that information.
What did I? Being without any sort of action on the admissions fund to increase the fees across the board, not just the bar exam, there aren't going to be sufficient reserves past 2026. As Donna mentioned, we really do not have the ability to even to be doing a remote exam until, July 2028, maybe. These fees are going through that period of time. I don't know that we would, come 2028, have a significant surplus, just because we're returning to a remote exam. And I think there's a lot of consultant expenses that would probably have to be incurred, right? Before developing any sort of remote exam. So that certainly will be additional expenditures that right now we don't know what they would be. So I don't anticipate all of a sudden going into a remote exam and having a huge surplus in cash, or reserves, I should say, for the admissions fund.
Okay, I just want to, go ahead, sorry.
I apologize. We are trying to build the reserves to get the admissions fund by, or at least through the next couple of years, where we have to do a in-person exam, but we haven't projected the fees past 2028 at this point.
Okay. I just want to comment while I still have the floor, that I'm against raising fees for individuals who are trying to enter the profession. As far as people who are already licensed in other jurisdictions, not really concerned, but that's just where I stand. Thanks.
Yes, Vice Chair Tony.
It's interesting that I was appointed, my first meeting was in 2021, and I look around and I am now one of the veterans. So I want to give a little history because it's important on this issue. When I was a member of the Finance Committee, I looked very closely at everything. And one of the things I noticed is that the admissions fund was running at a perpetual deficit year after year after year. And the reason was because the fees had not been reviewed or increased for 5, 7, 10 years in some cases, and in some cases, nobody knew how long it had been. Okay? And of course, as the costs increase, if you keep it steady, and I made the argument that if we were going to ask the legislature to increase the licensing fee, it hasn't been increased once in 20 years or whatever, that we had the responsibility for reviewing and increasing the fees that we had control over, which the admissions fees fall under. And so what happened is we reviewed them, and that is why in 2024, we adopted major increases. They were major increases in most categories. It was playing catch up. Maybe it was in 2023 now. But anyway, in 2023, we did that. At the time, I had suggested that we review them. Well, a couple of things happened. One is that we made a conscious decision not to cover the full cost, to get close, but to reduce some of the shock, the bill shock. I had wanted us to review every 2 years, but the general consensus was that we should do every 3 years, not 2 years. Okay? And I had said, well, let's at least do consumer price index in the in-between years. And so there's a couple things. One is I'm going to ask to be switched to the screen that has option 1 and option 2. Not that one. I would go back.
For the bar exam?
Yeah, that one, yes. Okay. I appreciate that more than one option is being presented. I'm going to suggest option 3. Option 3 is no increase. That's option 3. So, my argument for it is that I'm going to ask, because of the direction, there are certain things that are part of what I want to say that need to be brought up now. So so there's one question about that we got in comments public comment this morning and written comment. What is the State Bar doing to reduce costs? Show us. I think that's a fair question. And I don't think we've done enough to show. And when we get to a later part of the agenda, I'm going to ask some of those questions regarding contracts that we're being asked to approve in the millions of dollars with very little information. Okay, so that's one. Second is, there's a slide I had asked to be put from the Finance Committee discussion, the budget discussion. If Devin, you can do that for me, thank you. I'd asked her beforehand. I know she's working on it. But it's a snapshot I think is important to look at. It's from item 6.10. Excellent, excellent. So we won't be discussing this till later, but I think it's important to take a look at. And what I see from here, because there was the term used that the admissions fund will be insolvent. Insolvency was the word used. And so, you know, first of all, when I look at this, I do not see an organization on the verge of insolvency, okay? Insolvency is not about one little box of admissions. It's organizational. And what I see from this is that we have the room that if the admissions fund has a deficit, operating deficit for this year, I don't take issue with the calculation being presented, I think we'll be okay, one. Two, if you look at what it is that is in the agenda, for the, in this presentation, where did I put it? I'm in the different, if we do not adopt an increase, reserves are projected to decline to 10.8% at year end, which is below the board's minimum reserve policy of 17%. For me, that is not enough rationale. Keeping a reserve is not enough to vote for an increase. I would like us to consider an increase in 2026 when we had planned to do, and not to have an increase right now. I do agree with people who have said it feels like the future bar exam takers are being punished for the failures, and there's enough blame to go around for the failures of February bar exam, but that they're being punished for the failures of the February bar exam. So I will be joining Trustee Harrison in voting no on the proposal to increase, particularly the bar exam and the practical practice fee that was also mentioned.
Mark, may I I have a couple of comments, if I may. Yes, I think when you look at the state bars, this is the revenue slide from my presentation earlier that I will again present later at the board meeting, or tomorrow, I should say. When you look at the bar wide in total, yeah, it looks like we are good and we have a lot of revenue, but I do want to remind the board members that most of the funding, if you look, comes from the grants funds, right? And all of the funds are actually restricted other than the general fund. The general fund is the only fund we have that is restricted. Every other fund, this is most of them, but all the other funds are restricted. So we cannot just take funds from other, or actually monies from other funds without some sort of action. And I don't know how much we would even be able to do if that were ever an option. We haven't done it, I don't think, since I've been here, but certainly not. And then in the following slide that I'll present, we did a budget amendment in September to bring down the admissions revenue and increase the admissions expenses based on what we had seen as a result of the February and July bar exams. So if you were to look at the expense slides, which I was looking at them, it's 24.5. So as of September, and this is year-to-date September, right? We still have one whole quarter to go. The admissions, it has 24 million in revenue and 24.5 in expenses. So for September, they're at a $500,000 deficit.
I wish we could expand on that a little bit. I'm still not getting a good picture of where we are with the money and where we're projecting it to be and what supports the increase. So I'm presuming, should we look at the revenue slide, or is there another slide that would show us what's going to happen in the future year? You talked about, as Ms. Vice Chair Tony just mentioned, that the surplus would decrease. Was that overall for the entire organization or for the admissions fund? But a surplus decreasing, but still having a surplus doesn't sound like we're going to go negative, or are we? This is what I think is not entirely clear to me.
Mm-hmm. So the admissions fund, we have reserves for every single fund because they're restricted, right? The admissions fund itself, we are projecting it to be in a deficit spending position. Do you remember? Maybe you could look up how much we had projected for 2025. But we are projecting 2025, the full 12 months for the admissions fund to be in deficit spending. That means that we have to eat into the reserves. If we eat into the reserves at the end of 2025, going into 2026, we're only going to have 3.4 million in reserves to get us through 2026, admissions fund only. That 3.4 million, I think it's the 10% mark that you noted. So not increasing any fees for admissions in 2026. Yes, it may get us with, the reserves will barely get us through, but we will start 2027 with no reserves. That's where it becomes a problem.
Right, so that would have probably been useful to say we would be at 10% reserves at the end of the next year, and 10% reserves at the end of this year, which is, again, remind me, in a
3.4 million.
What date is the end of this year?
December 31st. December 31st.
In a little over a month, we'll be at a significantly smaller reserve, and 12 months from there, if projections stay even, we will have spent everything we have, including all of our reserves, leaving really no cushion, which is the whole point of having reserves.
Correct.
So if there's any miscalculations or increases, unexpected increases in the next 13 months, let's call it, then we would have no money to pay for those unexpected increases.
Correct. I will. I know February was a long time ago, but we had adopted for the first time an admissions budget that would have been in surplus with the assumption that we were going to have a hybrid exam. That one February exam completely threw the finances of the admissions fund upside down. So yes, there could be unforeseeable expenses and material ones that we don't know in the future that could really put the admissions fund in a lot of
So again, I don't mean to beat this to death, but we are talking about if we don't increase now, and if the next year's budget stays the way we were to predict, we're spending down our reserves to zero. We're essentially setting up a budget that not only spends our reserves, but takes us to zero reserves, no cushion, nothing else. And yet, Justin, you're going
It
to...
takes us past zero. Negative 400,000 is
So
what
we're
projecting.
we're actually spending money we don't predict we'll have.
And before the budget adjustment where we brought the revenue projections down for admissions, if you go on the original revenue estimate, it's $3.5 million less in revenue this year that admissions is going to collect. And we're spending $2.5 million more in expenses. So $3.5 million less in revenue, $2.5 million more in expenses. That's why we saw that big swing. But we will, if the projection, if we only apply the CPI, which is the board policy, to all of the fees and admissions, it's negative. It's 3.8 million. We only have a fund balance of 3.4 million, so it's negative 400,000 by December 31st, 2026.
So that would be planning to put ourselves into a negative territory if we were past that.
If we did nothing.
Right. Okay. Thank you. Trustee Gore.
Right.
So I want to understand the sensitivity around, if you raise the fee, you may have less people apply. So so even the revenue projections has to have some like, oh, wow, we didn't realize 50% of the people are not going to apply. So we're going to have a revenue. It's not necessarily automatic if we increase it, given the public response that we heard. So we may see a shrinkage in the population. And in particular, it feels like a shrinkage in perhaps the attorneys of color because of the barriers there. So I'm trying to balance the sensitivity of, oh, we're raising it, less people will apply, a deficit in 2 years, may still be realizing a deficit. So I know we've got this rock and a hard spot at this point. And the restricted funds also makes it hard to sort of say, oh, we got 3 million sitting over there. Well, we can't move any of that. But I'm wondering if there is any sort of fund balance flexibility that the board may be able to create in a one-time sort of situation, because we still, if we raise the fee, we still might be witnessing a deficit that will still hurt the balances. So I'm trying to see if there are any other tools at the table in dealing with these, restricted funds and the balances therein.
Trustee Sowell.
I appreciate Trustee Tony giving and providing a little bit of a historical perspective on how we've gotten to where it is that we've gotten as we've served together on the Finance Committee for a number of years. And we have wrestled for the last 5+ years or so with the bar's fiscal position vis-a-vis either the license fee or the admissions fund. And in previous years have actually gone to the legislature and asked them to lift some of the restrictions on some of the other funds that we have in order to be able to use some of those reserves in other accounts. I think it's also important for Audit to also talk about the position of the general fund, which is a fund that it does have that's unrestricted in its use, and we would be able to move some of that money around. And I'll allow her to do that in just a second. I just want to say to the Board of Trustees, about a month ago, the Finance Committee wrestled with this, and everything that you're raising, we talked about. I will tell you that I'm highly sensitive to everything it is that folks are bringing to the table, and I know that the members of the Finance Committee are as well. I do not want to raise fees, period. But I do not see any way around trying to grapple with this issue other than at this particular time and place that we may have to bite the bullet and do that. The February bar exam did us in, and we are suffering the fiscal repercussions of that. And so at the Finance Committee, there were discussions about philanthropic overtures to try to assist us in this regard. It turns out that the late fees that are in here haven't been raised in I don't know when. I can't remember what the answer to that was, but they're in statute. And so you can't raise the late fees, and so they haven't been raised in quite a while. We should go to the legislature and ask for that. That's not going to get us out of this problem, but it will help to sort of nickel and dime and sort of chip away at it a little bit. And so I know that there are a lot of other hands that are up. I don't want to necessarily belabor a lot of this, but I will just say that I don't want to raise fees either, but I think we just sort of find ourselves in this fiduciary hard spot. And I would like Araceli also just to talk a little bit about the state of the general fund. So even if we were to not raise fees, we really don't have a lot of wiggle room in other places. And we're going to find ourselves possibly having to go back to the legislature and say, help us out on the license fee side of this thing. Because of the use of the general fund to try to shore up some of these other accounts.
Okay.
She's one who never fell it answer.
I can comment really quick on
Go
this,
ahead.
on the status of the general fund. So far this year, through the 3 quarters, the general fund is doing better than expected. Our revenues for mandatory fees have exceeded our budget for the entire year already. We are, I believe it's a 1.5 million above budget as of the September 2025, which is the end of Q3. We also have received a lot of late non-compliance fees, so that's helped the general fund have more revenues than we had anticipated for the current year. What that means is that the general fund reserves are going to increase at the end of this year. I don't know. I think we'd have to do some kind of legal analysis if we could ever borrow or give, I don't know what the right term would be, of any general fund monies to the admissions fund. But I also want to remind the board members that in January 2028, we lose the $52. Part of the $52, and that puts us in a fiscal cliff come 2028.
Okay, thank you.
One last comment.
Yep.
I would just make note of the fact that I can't remember, was it July that this item was brought to us in terms of you wanted to raise the fee, wanted to raise the admissions fees, and we rejected it at that time and said, come back. And this is the comeback.
Okay. Trustee Barahona?
I think San Francisco was first, and then Trustee Harrison, and then I.
Thank you. Trustee San Francisco?
Thanks. The predicate for this whole discussion is that the admissions fund is funded only by fees. Why is that the case? Is that because the other funds are restricted? Is it that simple?
The admissions fund is a restricted fund. It's only funded by the programs. There's 11, 12 programs under the admissions fund, and they all charge fees, and that's entirely how it's funded. But it is a restricted fund.
Okay, that's fine.
Okay, who is next?
I think I'm next.
Okay.
So I just have a question. If the state bar decided to continue operating under its contract with Kaplan and not purchase the NCBE's product for the next gen or whatever for the delivery of the next bar exams, would that positively impact the money we have in our admissions fund?
So that is not an option that we have by the recently enacted statute. We would have to give 18 months notice if we wanted to return to a vendor other than the National Conference of Bar Examiners for the administration of the multiple choice. So without that, so it's for at least in the next 18 months, we have to use the multiple choice provided by the National Conference of Bar Examiners. There is on your contracts item today, you'll see that the amount, if memory serves, the amount for the February exam for NCBE is $325,000 for the multiple choice. So that is sort of in the range of the numbers, and about 2/3 of the test takers in February as there are in July. But that's the amount that in theory would be saved, but that also requires us to be ready to deliver the other multiple choice questions that we have. And we are redoing the content validation process in response to some of the criticism that was received after February. So we would not be ready to administer the anything other than the MBE for several more bar exams.
So just for clarification, you're saying that 18 months from now, we would not be ready to use the Kaplan questions after having already announced that we're going to use those questions so we can save the 300 something thousand dollars that we're paying the NCBE?
So we can, we would likely be ready in 18 months to do it. We have to give 18 months notice before returning to that. But we would be able to be ready if, assuming there are no other changes, if that is all we were doing is returning to that multiple choice, same content maps, et cetera, then we would be able to do that in 18 months.
Can I just add very quickly? There are many other things we have to do prior to giving that 18-month notice, though, that I think that's what we're getting at, is that it would have to go through this cost-benefit analysis and other things that Donna will talk about tomorrow in item 6.3. So it's 18 months from that date, but there are several things that have to happen prior to giving whatever notice, 18 months for Kaplan or 2 years for something else first.
So, I mean, let's turn that 18 months into 2 years, right? 24 months, just because of the other preliminary steps we would have to go through to vote for and assess the switch back, right? I guess the conclusion that I'm looking for is at that time, maybe 24 months from now, we would start saving over $300,000 because we're using the questions that we have from Kaplan under the currently existing contract we have with Kaplan. Is that correct?
Yeah, if we were to go back to the Kaplan questions and no longer use the NCBE's questions, we would not have to pay what is the $325,000 for February, will be more obviously for July. We wouldn't have to be doing that. Yes, that is a true statement.
All right, thank you.
All right, now Trustee Barahona.
Yeah, thank you so much, Chair. I think there's a few things to consider here. First is we have to have an ability going forward to be able to transfer resources within the funds. I understand there's a lot of potential legislative asks we would need to make, but ultimately at the end of the day, we will find ourselves in this position over and over again, whether it be the admissions fund or another fund. So at some point, there has to be a way we can do an interfund loan, for example, or an interfund transfer. There just has to be that ability, and there should be a threshold associated probably to it, but we have to have that ability just from a flexibility standpoint. It feels really important to sort of consider this. I'm sure you have already, but yeah, I think we'll find ourselves in these positions in years to come and with our hands tied each year. So that's one sort of thought I had. And the other thought is that, we won't be able to sustain the admissions fund simply with revenue from fees. We ultimately won't be able to do that, right? So part of me feels like there has to be a strategy to consider either leveraging public-private partnerships really clearly and having a strategy to do that, and even a pursuit, which may not bear fruits or in the first 18 months, but will ultimately. So I just think we need a diversified revenue strategy, even if 90% of our revenue for the admissions fund is fees. We need to have other revenue that we can leverage to do this. I think that's ultimately, that's a long-term strategy, but we have to do the work now to set the relationships up to support this. There is many, many different philanthropic partners that care deeply about access to justice. They care deeply about leaders of color in moving in through this profession and how important that is. So I think we have to have a strategy for that, and perhaps staff can think about that, and I'm happy to be of support of any kind if I can be for my board seat. So that's the other thing I wanted to share. And I think we just need to tackle this from different directions. Increasing the fees are a position that I think I hear Trustee Tony on this in terms of not wanting to increase any fees, but I think this is a both end scenario. I think some fees will need to be increased. Perhaps not the option 2 necessarily that staff is presenting entirely. Because I do think a reexamination of the PTLS fees is really important, given the public comment that we've received, in addition to the bar exam fees. And perhaps there is this option 3, where we are reducing fees, but we're doing that with a little bit more intentionality in those 2 specific areas. But we have to, I just think we have to plant the seeds now for a lot of other ways to diversify this revenue in the years to come. At the end of the day, I think we'll find ourselves in that similar position. So that's just what I wanted to add.
Thank you. Any other comments, questions?
Could I ask a clarifying
Yes.
question of Trustee Tony? When you're saying option 3 in changing the bar exam fees, are you saying no increase to just the regular bar exam applicant, but the attorney fee can be increased, or are you saying no increases for the bar exam fee?
I'm okay with, like Trustee Harrison, I care more about the bar exam fee than I do with the attorney fee. I, however, want to make sure we also don't increase, I can't remember the name of it, the practical training a law student fee, because they're not attorneys. Okay, is my understanding. They're not attorneys who are doing this. They're training to be attorneys, is my understanding. They're still students. So that would I would I would be okay with that.
Thank you.
If I may.
Yeah, please.
Yeah, so I think, oh, do you want to go ahead, Justin?
I can do quick calculations on those things if you want it. If we didn't apply a CPI increase to the student fee and also reverted, so not even CPI, just whatever the fee is now, it stays the same. So $850 for the applicant and $62 for the practical law student.
I would be okay with applying the CPI to the
okay.
bar exam, because that is our current policy.
Okay.
That would be, no change would be applying the CPI.
Okay, then change that one real quick. And just those 2 changes with the bar applicant and the practical law student would result in basically a $1.2 million deficit